Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish or Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. I don't know. Something's going on with StreamYard today. Did it cut my song off? Sounded to me like it cut my song off. There was a big delay before it even started. I don't know what's happening, but it's Monday. That's what's happening. Good morning. It is Monday. Today's Monday, November 18th of 2025. And thank you so much for coming to hang out with me today for a part of your day, or maybe your whole day, depending on what happens today. We are heading back to Norfolk Superior Court in Dedham, Massachusetts for the final pretrial hearing. Final pretrial hearing on the BRIAN WALSHE case. Jury selection is scheduled to start tomorrow, and then opening statements are going to be December 1st, unless he takes a plea deal. But I don't really see that happening here. I don't really see it happening. So it looks like we're going gavel to gavel on BRIAN WALSHE starting on December 1st. How's everybody? Did I say the wrong date? Today's Monday, November 17th. What day did I say it was? Did I say it was a different day? Sorry, it's Monday, November 17th, and it's 2025 still. And I look up in the corner of my screen to see what day it is, because I never know what day it is. How's everyone? Okay, it's the 17th. Sorry if I made you lose a day. You might have been freaked out. Boston 10 is going to be streaming today, so we're going to use their feed because they've got better cameras and usually better sound than the Zoom feed. And who knows if they're even going to turn the Zoom feed on today, because, they've stopped doing that kind of in Norfolk County. And we expect that BRIAN WALSHE is going to be live in court. He has been deemed competent to stand trial. That happened last week. We covered that hearing together. Let me just take a quick look at the docket and see what it is that we can be expected to hear today. I imagine we're going to hear many motions in lemonade, as the closed captions called them once during one trial, and then we sort of adopted that. And we call them motions in lemonade, but they are motions in limine, which are motions that are held before a trial in order to decide which evidence will be allowed in and which evidence will be excluded, or which parts of the evidence. And there's been many motions made. I believe most of them are still undecided, except for the motion to exclude the contents of the Google search of the iPad of BRIAN WALSHE's 6-year-old son, including The total extraction that was done on his phone and iPad, which in my opinion was outside the scope of the consent search. If you're not familiar with, you have no idea what I'm talking about. There's an entire Brian Walshe playlist below this video in the show notes. And we've done many, many videos on this case already. And long story short, Brian Walshe's attorney at the time and Lynn Beland, who was the right hand at the time of Michael Marcy, entered into an agreement in which Brian Walshe would turn his cell phone over to Yuri Bukhenik and John Fanning, and they would do an extraction of Brian Walshe's devices, but they were limited to looking at only communications between Brian Walshe and his missing wife, Ana Walshe, for a very finite period of time. I think it was a 10-day period between maybe Christmas and January 6th. Don't hold me to the dates. I'm just summarizing. But in true Massachusetts State Police fashion in Norfolk County, they did a complete and total extraction of Brian Walshe's cell phone and his son's iPad. And by doing that, they found a number of very graphic Google searches that were conducted on the son's iPad, allegedly. And they used those Google searches to get search warrants for other things, which led to other evidence, which in my mind is fruits of the poisonous tree and should be excluded. But the judge held an evidentiary hearing. Yuri Bukhenik testified. John Fanning testified. I think Connor Keefe testified too. And it was really interesting to see the difference in demeanor of Yuri Bukhenik testifying in front of Judge Diane Freniere, because I believe it was right after the KAREN Read trial ended, if I recall, and his demeanor in front of Judge Cannone and in front of Judge Freniere was like night and day, right? In addition to finding all of those Google searches in Brian Walshe's son's iPad, he was 6. They also got Brian Walshe's location data from his cell phone. And through his location data, which again, they did not have a warrant to look at, and all they needed to do was just go get a warrant, but they didn't. Michael Proctor is involved in this too. They got Brian Walshe's location data, and through his location data, they found out some of the places that he went in the days following Ana's disappearance on New Year's Day, January 2023. And they went to the places that he went, and they found some video of him dumping some big garbage bags into dumpsters. Most of those dumpsters had already been disposed of. They couldn't find what he dumped. But some of them, or in one of them, I think, they found some things like a Tyvek suit, a hacksaw, I think a watch and a necklace that they thought was Ana's because she had been pictured to be wearing them. They also got some surveillance video from some stores like Home Depot or Lowe's and Home Goods. And he bought a rug, and he bought cleaning supplies and a mop, and he bought a Tyvek suit. But they never would have gotten to those places without, in my opinion, the illegal search of his phone. Again, all they needed to do was to get a warrant. But as you know, and I know, and we all know, the Massachusetts State Police troopers assigned to the Norfolk County DA's office just do whatever the F they want. And they've never had any ramifications until now, until the KAREN Read case. Time to redecorate, Brian. And so they have all of this video of him doing these things that look nefarious. And Judge Freniere ruled on the motion to suppress that these things were allowed to come in because she, in her mind, thought that Yuri Bukhenik was incredibly believable, incredible, and that Brian Walshe's attorney, Tracy Miner, she is no longer his attorney. She is his white collar attorney for selling the fake eBay paintings on fake Andy Warhol paintings on eBay to an Andy Warhol collector, for which he was already under house arrest at the time of Ana's disappearance. The judge credited Tracy Miner's testimony very little. Yeah, because she said so, ipsy dixit. And she didn't believe Tracy Miner. She believed Yuri Bukhenik. And so the judge ruled that all of that evidence can come in. Brian Walshe's amazing attorney, Larry Tipton, who is, in my opinion, the best public defender in Massachusetts. He defended Penny McGee. We watched that trial together. And Larry Tipton took it up to the SJC and they decided not to hear it. They were kind of like, yeah, well, if he gets convicted, you can come back then. Is that really fair, though? Is that really fair? Shouldn't all defendants be treated the same? And should the Massachusetts State Police troopers just be allowed to do whatever the hell they want in violation of all kinds of constitutional rights? Because Massachusetts is where your constitutional rights go to die, as you know, if you've been covering or handling or listening to my coverage of KAREN Read trial, the Aidan Carney saga, and so many other things that we've listened to in Massachusetts. It just seems to be the upside down, inside out Narnia of trials and legal cases in the United States of, as such, America, in my opinion. Yeah, we don't want a whole episode. So can't wait to see what the evidence brings. There's a lot of stuff. There's a lot of stuff here, a lot of interesting things. Apparently, Brian Walshe's mom hired a private detective to follow Ana to Washington, D.C. because she was living in Washington, D.C. most of the time, where she was a real estate person. She also managed an apartment complex in which some very shady stuff had happened about a year. Was it a year prior? In which there were a bunch of guys living in the apartment complex who were trying to infiltrate the Secret Service under Biden. Do you guys remember this? It's kind of crazy stuff. Yeah. She was also having an affair with the real estate broker that sold them that Washington, D.C. apartment. And she went with him to Ireland for Thanksgiving. And so I believe that it will come out at trial. Brian Walshe's mother thought that Ana was cheating on him and hired this private detective. That's horrible. Hired this private detective to follow her because she had her suspicions, like, maybe like Mama Adelson. I don't know. But Ana's body has never been found, tragically. It is very sad. And then Ana didn't come home on Christmas Eve. And she told Brian that her flight was canceled. And then she drove back from DC to Boston, I think on Christmas Day. So there's a lot of stuff. There's a lot of stuff here. Will it be enough for reasonable doubt for a jury? I don't know. A narrative had been spun in the media that there was some bone that was attached to, let's say, the hacksaw. That was human bone. That has not been confirmed. It is not human bone, in fact, or animal bone. And so there's just a lot of very interesting twists and turns here. But I guess we're going to see what the evidence shows before I can decide whether I think he's guilty or not. Listen, innocent until proven guilty. Many people have surmised that this could be some type of Gone Girl situation or some type of spy situation. We'll see what the evidence bears out, whether or not Larry Tipton is going to use that at all in his defense. I don't know if she rented a car, Jenna. I saw this too. Jenna says, someone asked the other day about the rental car she drove home to Massachusetts with, and I'm so interested in when she returned it. I don't think it was a rental car. I think she kept a car in DC. And so I think it was her car. But if anybody has any other evidence to the contrary, let me know. Here we are in Norfolk Superior in the big courtroom. And look at this time. Can you believe it?
She's extremely efficient. There's nothing she hasn't read or reviewed or studied or.
I can hear a hot mic saying she's incredibly efficient. There's nothing she hasn't studied or reviewed. I don't know if they're talking about the judge or if they're talking about me. Right, cracking. Or she never left Boston to begin with. She was driving. Said she was driving home. Right. People have surmised that as well. And the courtroom's empty unless, well, there's people sitting there, so they have started letting people in. I'm surprised that there's not more spectators. I'd be there if I lived nearby. But I'm here with you, and I'd rather be here with you, so that's cool.
All I see is a nice fresh out of Sarah.
Whispering. I guess they don't realize that Boston 10 has hot mics. Thank you on top for your super sticker. I appreciate you so much. Proxy got waffled. Thank you for gifting a membership. Hello, Cherie. Cherie's been here for 13 months, all the way from Australia. Good morning, mate. I had a nice weekend. Did you? Did you have a nice weekend? Sandy B's been here for 19 months. Good morning. Sorry, been having major medical issues. I'm so sorry, Sandy. Sandy B, prayers up for Sandy B. Sending you all the healing vibes, and I hope you're feeling better soon and that you're not in any pain. Thanks, Betsy. She says you made my Monday better. Love you, Mel. Thanks for your 10. I love you more. And thank you, Michelle Lee. Just a simple thank you. You're the best. Thank you for your $5 super chat. I appreciate you so much.
We'll bring him, she'll ask for him to be brought in.
Such a spy. I feel like such a spy when I listen to
I
them.
thought there was. Like the gallery can look at it.
If we can have that, like,
I think they're asking for a screen for the gallery to look at. Maybe they haven't started letting people in yet. Is anybody in the chat who's actually at the courthouse today? Just me. Thanks for your 10 cents. Good morning. Thought of you while I watched the sunrise at Red Rocks. Oh, today? I love Red Rocks. It's my favorite venue. Left a cupcake note on the community wall at Launch Coffee Shop and survived the Manitou Springs incline. Congratulations. That's a rough climb up to Red Rocks if you're not used to the altitude. It is. I love Red Rocks so much. Thank you, Just Me, for your 10. Yes, Nate the lawyer. I do not know Nate the lawyer personally, but let's put prayer hands in the chat. I've never had the pleasure of meeting him. He's amazing. He's a law tuber. He has been diagnosed with a brain tumor. He was supposed to undergo surgery yesterday, but from what
The matter of the Commonwealth versus Brian Walsh, criminal indictment 2023-0091. The matter is scheduled for a final pretrial conference this day. Defendants represented by attorney Larry Tipton and Kelly Porges, and the Commonwealth by ADA's Greg Connor and
just pausing for 1 minute to say prayers up for Nate the lawyer, brain tumor. He was supposed to have surgery yesterday. Yeah, I understand it's been pushed a couple of days because they want to do some more testing. So Kurt from Uncivil Law, I believe, is in the hospital with Nate the lawyer, and he's been posting updates. And so we pray for him, as we do. Let me know if I need to boost the volume for you.
Yaz and Tracy Cusick. Counsel, starting with the Commonwealth, kindly identify yourselves for the court and the record.
Good morning, Your Honor. Gregory Connor for the Commonwealth. With me as Assistant District Attorneys Ann Yaz and Tracy Cusick.
Morning. Good morning. Good morning, Your Honor. Kelly Porges on behalf of Mr. Brian Walsh.
Good morning.
Good morning, Your Honor. Larry Tipton for Mr. Walsh.
All right. Good morning to everyone. We can bring the defendant in.
Waiting for Brian Walsh to be brought in. We're a tiny bit behind, so we can scooch.
Comfortable if Mr. Walsh remained uncuffed, at least his hands during the proceedings, so he can take notes.
Check that with the court officers. I defer to them. I don't have any, as you probably know.
Okay.
I don't have any objection to that.
Okay, I'll check with him. Thank you.
I'll check with them when they come back in with them.
Okay, thank you.
They're asking for Brian's hands to be uncuffed so he can take notes.
I certainly don't intend to have his hands cuffed during the trial, so.
Of course not.
I like Judge Freniere. She's on time, prompt, not waiting around like we did a lot of the time for Judge Cannone and other judges.
Thank you, Madam Clerk.
This case had originally been assigned to Judge Cannone. For those of you who did not know that. Here he comes. What's the over-under on the haircut today? Oh, he's wearing his favorite green tie. And hair's looking a little better. Maybe they got a better barber over at the Norfolk County Pokey. LC, I think, has been transferred. He was the inmate doing haircuts for $5. And I think he took great pleasure in making Harry Turk look like he got his haircut with a hammer. Thank you. I think in song lyrics 3-5, I think he is likely guilty, but due process matters, and he's being denied that because of corruption. Thank you very much for your 5,
Also,
Jen.
for the record, the handcuffs have been removed from the defendant so that he can fully participate in today's hearing. So the purpose of today really is to go through the motions and eliminate, see where I can give you some rulings and some expected rulings. I always say expected rulings because I like to think of a trial as a living, breathing thing that evolves, not something that is pre-planned. So these are my best guesses. Sometimes
Is the court volume okay for you guys?
I'm making actually affirmative rulings because I know enough that I don't think anything will change, but if it does change, I'll let you know. So I'll just start. I'm going to go through those motions that we went through a couple of weeks ago in the same order as they're listed. Instead of, I'll start first with the pretrial motions. And what we have left over there are the following. And before I move to the motions and eliminate, I'll give you an option to check in on others that you think that I might have missed. So first motion that I think needs tending to is paper number 184, which is the Commonwealth's motion for use of streaming platform to prevent juror exposure to extraneous matter with an affidavit in support. The defendant did not object. The request is to use the standard Zoom format. The court intends to do that. And so that motion is allowed. There will be no other streaming platform used in this trial other than Zoom.
Wait, what?
Any questions about that?
Your Honor, just briefly, there's the standard Zoom platform in which remote users are able to unmute themselves, and then there's the other version where they can't. I don't know what the name of that is. Are we using that version?
We're using the version that they can't unmute themselves.
Thank you, Your Honor.
I don't know if that means that I think that still means that.
Paper number 185 is the Commonwealth's motion for an order to prevent juror exposure. This is called the stay away, no contact order, so to speak. I don't know that we're going to need it. It's hard for me to judge what is going to be the appetite for either demonstrators in this case. I don't see anybody outside yet. And I'm hoping it stays that way, frankly.
Your Honor, I think the parties are all also hoping it stays that way. In the event that there's any information suggesting that there might be any sort of demonstration outside, how could we communicate that best to the court, information that we might?
Through the clerk, the best point of communication.
Okay, first of all, understand that Zoom is not the same as whether or not a camera is allowed in the courtroom. They're going to allow a camera in the courtroom, and so that's a different issue. Don't worry about that. We're still going to be able to watch a good feed like Boston 10. Also, I'm going to suggest to the court, if they're listening, December 5th is a big Turtleboy hearing in the same building. You might want to have a half day that day because his hearing is scheduled for 2. So if you're trying to avoid the supporters, they're not going to be for BRIAN WALSHE, but they will be there for Turtleboy. So they probably know that. Maybe somebody will bring that up.
Communication always is Madam Clerk.
Thank you, Your Honor.
So if things change outside, and I have a skewed version of it because I sit out on the back, so I don't see what's going on out on the front of the building. But if it changes, you let us know, and I won't hesitate to order that because of premier importance to me is keeping that jury that we pick in their fair and impartial state throughout the entire term of the trial. So the supplemental questionnaire, I'll get that to you today. I did add in, as requested by the defense, or I changed those 3 questions to be 3 separate questions. I added in the additional question that the defense asked. I think at the side of the bench on Friday, the Commonwealth indicated to me that it didn't have any additional edits to that. And I did see some motions came in this morning. I can't say that I spent a lot of time looking at any of them, but I did see that there was a revised witness list, which the Commonwealth eliminated witnesses that it no longer intends to call, and added a few witnesses. Which reminded me, so I'm gonna, that witness list as abbreviated, we talked about cutting out the custodian of the records and adding in the defense witnesses to the appropriate subheading. And not on Friday, but previously, I think I said to you that, said to the defense to take a look at where I put them to make sure that I put them in the right bucket, so to speak. Have you had a chance to do that? And are you content with where I put them?
I know I looked at it, Judge. I remember, but I think that it was fine. And I'll take a look at it before I leave today, but I think it's fine.
Okay. So what I'm probably going to do is take the new witness list from the Commonwealth and then add those people back into the same spots that I put them on the prior version, rather than try to figure out who the Commonwealth took off. But sometime this afternoon, you're going to get the questionnaire and you'll get the attachment that I intend to, and just take a look at it for the final. We can always make changes in the morning. And while I'm on the topic of questionnaire, I think I told you, I think it's the most efficient way to get the information to you, and the least logistically challenging way is the way I've done it really in almost every case that I'm using a questionnaire now, which is those questions are designed in a particular way such that a yes response requires further follow-up. And so when that person comes in, and I'm pretty sure now that we're going to be impaneling in this courtroom. I didn't think that the last time I talked to you, but based on what's happening in the other courtrooms, I can't get a clear courtroom somewhere else. So we are going to impanel in this courtroom. We'll be using the whisper technology for strikes. When the person comes in and is seated, I will follow up on any missing information on the statutory questionnaire and any yes answers to the questionnaire. And then I have a few more follow-up questions if the person's still standing and is still a viable potential juror. One of the questions that I think I'm going to ask in that individual voir dire is to tell the prospective jurors that during the course of the trial, they need to agree not to be on any social media, and they need to agree not to watch the news in any medium. That's a big ask, but I think it's a necessary ask given the level of publicity, media coverage in the case. Anyone have an objection to that?
No objection. Objection, Judge?
I mean,
Can I just,
that's a big ask. Like, would you agree to do that for 4 weeks or however long this trial is going to be? Would you agree to stay off social media and not watch any news at all for 4 weeks as a condition of being on this jury? That's a big ask. And that's going to limit the number of jurors that are going to be willing to serve on this jury, in my opinion. That's a bit much, right?
ask a question, Judge? I looked at my notes from our last discussion. I read my notes to say you weren't going to give us copies of the questionnaire.
That's right. So how do I do that?
Yes.
So you'll have a blank questionnaire, of course.
Mhm.
And so what I do is I have the person come in, I tell them in the impanelment script, you fill that out, give us your honest answers to the questions, you fold it together, and you keep that document in your possession. Don't show it to anyone until you hand it to me. So they will come up to the side of the bench, they will hand me the questionnaire. I will then recite. The juror number 40 answered yes to questions blank, 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 and blank. So you'll know what questions they answered yes to. And occasionally people don't answer and they'll put a question mark or they'll write something. And if that happens, I read literally what they wrote and where they wrote it. And if you at any point want to look at the questionnaire, that's fine with me too. I just want to prevent the both the time and the paper that's involved. Jury selection is so paper intensive anyway. The last thing you need is more questionnaires. But if you want to look at the questionnaire at any point, that's fine. And then at some point, the very last question, as you know, on the questionnaire says, whether this would disclose anything that would be personal to you. I presume that some number of jurors are going to answer yes to that question. At some point, typically at 1 o'clock, I will have the required hearing under URIP to seal those questionnaires. And you have to give, under the rule, you have to have a hearing. So it'll take about 2 minutes, but we will have that hearing at some point during the early stages of the trial.
Thank you, Judge.
That's unusual that she wouldn't let the lawyers see the questionnaires while they're picking, but they can go up and look at the questionnaires. I believe in the Karen Read case, they got copies of all the questionnaires. And as they went through the jurors, they each had a copy of their questionnaire. That's unusual to me. And I don't know how that's going to fly, but Larry Tipton doesn't seem to be disagreeing.
The Commonwealth filed a preliminary request for jury instructions. I just want to bring that to the defense's attention with regard to the elements of all of the crimes, so that if there's any objection to that, the murder one is really the SJC's. And I don't know that you're going to be dabbling with that, but with regard to the others, just take a look at those so that we're all on the same page with regard to the elements that are attenuate to the other crimes, all right?
We have, Judge, and at the appropriate time, we do have an objection to some of their requests, but we'll deal with that when that wants to.
Okay. I think we're a little before that point, but I'll be happy to hear you whenever you want to bring it to my attention. We've dealt with on Friday the motion for change of venue. And we also, I guess implicitly, if not explicitly, have addressed the defendant's motion for leave to conduct attorney-conducted voir dire to the extent that the defense is asking for panel. I'm not going to exercise my discretion. I'm going to do the traditional individual voir dire. And of course, you play a big role in that.
The motion.
That's all I have for non-motion in limine pretrial
Motion for change of venue was denied.
motions that I think that I could give you some rulings on. Before I move to the motions in limine, is there any other non-motion in limine pretrial ruling that you're looking for?
Your Honor, the Commonwealth did file a motion for reciprocal discovery.
Okay.
The defense did provide us with a notice of intent to call Dr. Banerjee and an outline of Dr. Banerjee's opinion if she testifies. The Commonwealth is requesting the proposed potential testimony of Dr. Lakin and Joel Scoletti of Safos Corporation, who are identified as potential experts by the defendant, and also Dr. Dan Ferrier and Steve Verino of MVP Forensics, also identified as potential defense experts. And also Tim Creamer has been identified as an investigator. Commonwealth is requesting any statements that Mr. Creamer has obtained, and also the substance of any testimony he may offer.
Wasn't Steve Verino on the taint team for Aiden Carney and also for Karen Read? And now the defense is calling him as a witness. That's very interesting. And Jay, if you don't like the commentary, you can go watch it on News 10 YouTube, because they've got it streaming without commentary. Go watch Law and Crime. I have to do this for fair use, and this is what I do because I'm a legal commentator. I'm not going to change the way I do things because you want me to play the stream uninterrupted for you. Have a great day.
We have no opinion. We have no reports. We have no statements. I will, though, provide them with a summary of what I anticipate the other experts would testify to. I'll do that. And
All right, when can you get that to them?
Pardon?
When can you get that to them?
Wednesday?
Seems reasonable. Any other non-motion and limine motions? All right. So I'll move to the motions and limine, and I'm going to take them in order, I think, with the exception of maybe one of them. When we get to it, I may pull that to the end. So paper number 180.
Let me just address that now. Jenna says, so both sides have to give the other their discovery. Well, the Commonwealth is saying that the defense has not given the Commonwealth their expert testimony, and they want to know what their experts are going to testify to. And Larry Tipton said, okay, I'll give you summaries of what they're going to testify to by Wednesday. And that's really what they meant by reciprocal discovery from the defense. I guess they haven't given them that yet because nobody was really sure if the trial was going to happen because of the competency issue. And that was all just decided on Friday, and today's Monday, and the judge has jury selection starting tomorrow. So the most important thing to decide for today is the jury questionnaire and what the jurors are going to be asked and how jury selection is going to be conducted, because the motions in limine and the evidentiary issues are less time sensitive because they're not going to open until December 1st. So there's a lot of time, but hopefully she can get some of these decided today at least.
7 is the Commonwealth's motion to limine. So paper number 187 is the Commonwealth's motion to limine number 1. It's to provide the jury with a means to review electronic exhibits during deliberations. And the defendant did not object to that as of at least 10/31. Same position today, right?
Yes.
It's allowed. The Commonwealth needs to ensure that the laptop that is in the jury deliberation room is contains no other information other than the information that's necessary, the software that's necessary for the jury to review the material evidence.
We will do that, Your Honor. There is a special laptop that will be used for that purpose, and it will be provided to the defense to inspect it.
All right, and that was the second part of my order, which is the defense is ordered to review that laptop before it goes in to make sure that we don't have any glitches. Paper number 188 is Commonwealth's motion in limine number 2. It's to notice of any visual aids defense intends to display during opening statements. The defendant objected to that. Is the defendant still objecting to that?
It is.
Larry's up.
The motion is allowed. As to opening statements, I want to see any chalks that you're intending to use. It's for your own good. Because if I determine that there's something on that chalk that is inadmissible, you are not going to be able to use it because you're not going to be able to turn it around. Go right ahead and state your objection on the record.
Well, Judge, I would just like to explain something. I object to it for a very simple reason. I've been doing this for 20 years. I've never had an objection in either my openings or my closings when I've used visual aids. Secondly, I only include visual aids that I know are going to be exhibits that are admitted. If I have any question about anything that I would use visually for the jurors, I approach the DAs, I approach the court, make sure that we're all in agreement that's an exhibit. I don't use
Then why are
charts.
you objecting to it then?
Because it gives, if I give it to the Commonwealth before I make my opening, they have a roadmap, they have a preview of what we're going to say.
Everyone's supposed to be getting a preview of the evidence.
Not of my opening and not of my thoughts.
Right. I'm not going to engage in a discussion about this. Any chalks that you intend to use that are not agreed to exhibits need to be shown to the court and to opposing counsel.
Okay, Judge, just so I
And
understand.
it can be the morning of, but it's going to be before
Oh,
you're
okay.
holding something up in front of 16 jurors that we spend 2 weeks picking a jury for. Not happening.
And I don't want it to happen, but let me just clarify something. I understand the court's ruling so far. Chalks, but not what we know to be exhibits.
If you have, and I know you have, agreed to exhibits, then you don't need to address that. Those are agreed to. You know it's agreed to. You can show those.
Fine.
If you have chalks, different thing, that you want to put in front of the jury, I am not letting you stand up before the jury without me seeing it first, and the Commonwealth see it first. It can be the morning of, but I do not want you showing a chalk to our impaneled jurors without me seeing it first.
I understand, Judge.
Oh, he's already getting insulted on a Monday morning. I see a lot of questions about chalks. Chalks are just big exhibits that they hold up in court. They still call them chalks as if they're on a chalkboard because Massachusetts is in a lot of ways behind the times. It's like puritanical law. And so chalks are another word for exhibits, like big poster boards that you would hold up. Remember the Karen Read trial when Liza Little held up the big poster board of a picture of John O'Keefe's arm? That's a chalk. CHALK. Old term for like poster. Excellent, Mama MSN. She wants to see it first, even the day of. But he's saying, listen, I've been doing this for 20 years. I know what's allowed in and what's not. And I don't want to give them my theory of the case so that they can then craft their opening around my opening. My opening is my opening. It's my words. I want to be able to have some sort of a surprise. And she says that if it's already an agreed to exhibit, it's fine. But if it's not, then she needs to see it. But even the morning of, and I say the morning of is fair because then it doesn't give Greg Connor, whoever's going to open for the Commonwealth, the opportunity to change his opening to fight against Larry Tipton's opening. And openings are not evidence. There we go.
All right. Paper number 189 is Commonwealth's number 3. It's for notice of any third-party culprit evidence. The defense has indicated that he understands what the rules are and you're going to abide by them. There's no ruling necessary. Paper number 190 is Commonwealth's number 4, notice of any proposed reputation testimony. It also relates to, I have them in my notes, see paper number 193 below. 193 refers to any bad character, bad reputation of the victim or any of the witnesses, and alleged prior bad acts of the victim or any witnesses. The defense has objected to that, arguing that he intends to bring in evidence of general reputation evidence. Is that right?
Your Honor, at this point, we don't have any notice of specific reputation evidence that we'd either offer through cross-examination or in any case in chief for us.
Okay.
The concern I do have is the Commonwealth has indicated they expect to introduce evidence, quote unquote, that Ana Walshe was a loving mother who would never have abandoned her children and was a dedicated employee. So I'm sure the government is aware of the restrictions on how this evidence will come in, but that may or may not be relevant. And so I'd ask the court to revisit this before they seek to put this information in.
All right, Commonwealth.
Thank you, Your Honor. Your Honor, the Commonwealth does plan to call witnesses who will testify as to their observations of the victim at her employment. Her employer will testify, as well as her former employer, who was the New Year's Eve guest, will testify as to her.
Is it Metlu or Mutlu, or how do you pronounce his last name?
Mutlu, Your Honor.
Mutlu?
Mutlu.
Okay, I'll try to remember that.
Thank you, Your Honor.
The Commonwealth will be introducing evidence to those persons regarding the victim's work ethic and
Observations or interactions with the children?
yes, Your Honor, observations and interactions with the children.
All right. I'm not going to give you any firm rulings on it. You raise your objections at the time. I will tell you generally, that I probably will allow observations of her, not to an excessive amount, whatever that in my mind becomes excessive. But general observations as to the victim's interactions with her children is permissible.
Your Honor, I would just add that the law is clear on this. They can't have specific acts. So an observation would be a witness giving their opinion or testimony on a specific act. And so that's not admissible. What they're allowed.
You're right, opinion or testimony.
So observations, how are observations of her with her children relevant, which I suspect may or may not be relevant once we start? And it can't just be a limited number of people. So one person from her work saying that she had a good work ethic, the case law says you cannot do that. It has to be the general reputation of a community. And so I guess we will just raise the objections at the time. I just wanted to put the court on notice that
Right.
any of this testimony could just be inflammatory and prejudicial and invoke sympathy of the jury to hear that she was a great mother and a great employee.
All right. I hear your objection, and I encourage you, and I know that you don't need any encouragement to make the real-time objection at the time of the trial. And I'm just trying to give you some basic guideposts of what my present thinking is with regard to that evidentiary issue.
Yes, that is Greg Connor for the DA's office, and the female attorney with Larry Tipton is Kelly with an I, Porges, Porges.
Anyone want anything more on that particular motion?
No, thank you.
Not at this time, Your Honor.
Commonwealth's number 191, motion to eliminate number 5, is to allow in-court identification the defense asked for, and the Commonwealth has now given, I see this morning, a list of the witnesses who will so identify. Any issue that I need to be aware of with regard to that?
No, Your Honor.
All right.
Okay, that is nothing more than the witness on the witness stand being allowed to say, when asked by Greg Connor, do you see the defendant or do you see the man that you know as BRIAN WALSHE in the courtroom? And the defendant can point at him and say, yes, that's him in the green tie. Nothing more than that. That's all that means.
So that motion is allowed without objection, and the Commonwealth has satisfied the defense's request to provide names
It's
as
always
of this
allowed in
date.
Massachusetts.
Number 6 of the Commonwealth's motion to eliminate is to preclude reference to or introduction of irrelevant conduct of testifying and non-testifying police officers and agencies. The defendant objects, and I'm happy to hear further argument on this if you wish, but the defense's objection to me was, I wrote in my notes, it depends on what the Commonwealth does in its case in chief. And so you've alerted me to the issue, and we'll take it as we go along. With regard to
Michael Proctor has entered the chat. Alert, alert, Michael Proctor has entered the chat.
a preemptive ruling in that regard, nor do I think that it would be part of your opening statement, because the opening statement is supposed to be a preview of what the evidence in the case will be. And so the defendant may not open on this without raising it with the court. It wouldn't be expected testimony at this point based on your opposition, or seek to introduce that evidence without readdressing it with the court affirmatively at the time that you're going to do it. All right? Commonwealth's number 7 is paper number 193. I think we just went over that with the other one, so I'm going to bypass that. Paper number 194 to Commonwealth's number 8, to admit photos of digital devices rather than the actual devices, and the defendant did not object, and that's current today. That motion is allowed without objection. Let me pause on 195, because I think we're going to have to go through. Let me just say, first of all, Commonwealth's number 9 is to admit the defendant's 4 recorded interviews with the police. I saw this morning, but I haven't really had a chance to look at it. The Commonwealth supplemented its legal briefing with regard to statements of Miss Miner and of the minor child. I want to look at that, and I want the defense to have an opportunity to look at that. I looked the case over quickly this morning, but I frankly didn't have much time to deal with it. But I'm going to circle back to that motion because I think we're going to have to go sort of on the micro level and start going statement by statement, which is going to take some time. So I'm going to put that towards the end of this hearing. Paper number 19.
Yes, you might be shocked, but the Massachusetts State Police did record Brian Walshe's interviews, all 4 of them. And they want them played at trial. And she's going to address that later.
96 is Commonwealth number 10, to admit NCIC missing person form for Ana Walshe. Defendant didn't object, correct?
Correct, Judge.
It's allowed. Paper number 11 of the Commonwealth's motion in limine to admit photos and a short video of Ana Walshe as she normally appeared. The defendant objected. So I haven't seen the video. Does the Commonwealth have a way to show me the video?
I believe we could email it to you, Your Honor.
I meant like right now.
Your Honor, I have it on my computer. If you can give me a moment, I can walk up to the bench.
That'd be great.
Yeah.
Generally, what is the video of?
It's her with her 3 children on a rug in the living room of the home.
And why is it important?
The rug, an identical rug was found in the dumpster outside of the defendant's mother's home.
Oh,
Your Honor, I can approach, but just what might make it easy is the video is unnecessary. They could do a screenshot of the video which portrays the rug in question. If I can approach it, I can show you.
Yes.
Yeah, sure.
it may also show her wearing, I think there was a necklace and a watch found in the dumpster as well. And if you look at the photo on my thumbnail today, I found a photo of her on her Instagram, which is still up, wearing a Gucci necklace and what may be an Hermes watch. And I think, are those the 2 things that they found in the dumpster? Correct me if I'm wrong. And the rug will purportedly match the rug that was found in the dumpster. Thank you, Unsolved Amy from Boston, for being here for 20 months, as many
I
months.
think it's
Loving you.
incredibly inflammatory, and if their sole reason for introducing that is to simply show that that rug was in the home, they can do that with a screenshot.
No objection.
All right. That's the ruling you were going to get. So it's good that you, there is no reason that the video needs to be played. So just take a shot of it, show the shot. Now,
I'll sit
with
down.
regard to the other photos, you need to use, it's sort of like autopsy photos, in my view. Use the least number you can use to get, I understand that's one picture she's wearing a necklace and one more picture she's showing the watch or something else. But use the least number that you can use.
If I may, Your Honor.
Yes.
So I agree with that, and we tried to cull it down. So there's one with a jacket, there's one with a watch.
The black jacket.
Yes. There's one with a watch, and there's one with a necklace. We can probably take away 1 or 2 from what we submitted, because I believe that there's one where she's with Mr. Mutlu wearing the watch. So maybe we can delete that one. So we're talking probably about 4.
Your Honor, the other issue is those photos can also be cropped, and there can be a stipulation that the cropped photograph showing a person wearing the necklace, the coat, is in fact a photograph of Ana Walshe. So they have sent a parade of photographs. I think that there's other ways to serve that purpose, and some might be stipulations. So this.
Well, I'll let you work out whether you have any stipulations, but even if you want it that way, doesn't mean that the Commonwealth wants it that way. And the Commonwealth gets to, hold on one second.
Excuse me.
You're right, Mel. They never found her body. Her body's never been found. You are correct.
No.
I'm curious if there's nudes of her on Proctor's phone. Because there seems to be some stuff that's very relevant to this case that was found on Proctor's phone. And we're going to find out what it is. Commonwealth has said they're not going to call Proctor. The defense says they are. So this is sure to be exciting. And Bukhenik must testify in Proctor's absence. And Fanning testified during the evidentiary hearing that he backdated a report that he just drafted, I don't know, in 2025. He backdated it to 2023, like it was no big deal. So that'll be an interesting cross as well. You might want to tune in for that one too. You just had them. I saw them. Also, keep in mind that during the time that Ana Walshe went missing, BRIAN WALSHE had an ankle monitor on. So I saw somebody ask if he had any access to deep sea boats. He had an ankle monitor on. He was only allowed to leave his house for certain things, to drive the kids to school, go see his mother, and things like that, because he was on house arrest for his federal case in which he allegedly, or I think he pled guilty to selling those fake Andy Warhol eBay paintings.
All right, I think I was saying that you may be able to reach a stipulation. I don't know if you can, if you can't. But I think I was just about ready to say that the Commonwealth gets to, within the bounds of the evidentiary bounds, gets to present their case.
I appreciate the analogy to autopsy photos. And so let me go back and see if I can do something that's more palatable to the defense.
That's frankly how I see it. I mean, I understand the significance of the various items that we've just listed to the Commonwealth's case, or I think I understand generally what the significance is to the Commonwealth's case. So I'm inclined to let them have the photos that they're going to need to make those arguments. But they don't need to be inflammatory. And so, yeah, just look through the lens of an autopsy photo.
Thank you, Your Honor. I appreciate that, and I'll work on it.
Yes, we did learn that his ankle monitor did not track his location, only the times that he left his house. But somebody was asking if he had access to a deep sea boat, and my response was in response to that he would not have been able to be out on some deep sea boat for some long period of time without being violated. So yes, although the ankle monitor did not have GPS, the time that he would have been gone would have been way too long for him to be out on a deep sea fishing boat. Capiche?
All right. Commonwealth's motion number 12 to admit evidence concerning the defendant's federal charges. And the defense is opposing in part. I'll hear from the Commonwealth first on this one.
Your Honor, we have actually attempted to develop a stipulation. The Commonwealth had sent it to the defense, and we haven't heard back as to whether that is something they wanted to stipulate to. We had been working on potentially reaching an agreement as to what information about the federal charges would come in.
All right. Well, to aid you in your discussions, it seems to me, and this actually overlaps with regard to the one of the other motions with regard to the interviews. I understand the importance of the federal case in terms of the Commonwealth's argument with regard to motive, and particularly the timeliness of certain information vis-a-vis the time that the Commonwealth indicates that they believe the defendant did the acts that he's charged with. And the one area that I wanted to probe so that I have the information firmly in my mind, what the evidentiary significance of it is, the weight of it versus the prejudice, is the GPS. So my memory from prior proceedings on this case is that the GPS was not the way that the Commonwealth found out that BRIAN WALSHE was at various places.
Right.
That is correct, Your Honor.
All
It
right.
was not a GPS bracelet.
What was it?
It was a radio frequency bracelet that would go off if he went a certain distance from the home, and he would have allotted amount of time to leave the home to perform errands and drive the children.
Okay. So there's no evidentiary, there's nobody coming in and saying based on his bracelet, he was at X, Y, and Z. They found that from the phone, right?
That is correct, Your Honor. They found it through the two phones.
So that seems to me to be both in the transcripts and also just to the extent that it's in any of the federal papers as a condition of release, highly prejudicial. And I'm not inclined to let the jury hear about that. It's not relevant to their decision-making, and they may, even if I give them a limiting instruction, may make it difficult for them to accept the limiting instruction. It doesn't have any evidentiary value.
Okay.
So anything with regard to both in the interviews, which I know we're tabling for later on, and or in the federal records, that seems to me to have very little evidentiary value to the Commonwealth and has a potential for prejudice to the defense. So that won't be in.
Understanding you've made a ruling, can I make an attempt to change your mind?
Sure.
All right, thank you,
Go
Your
for
Honor.
it,
I
dude.
appreciate you giving me this opportunity. So with the defendant's ability to have windows of time that allowed him freedom to leave from the house, it allows the Commonwealth to show the premeditated nature of this crime and that he had windows to clean up after the crime was occurred.
That's a different thing, though. The fact that he has windows of time that he, or certain parameters that he has to be at home, and that comes up in the interview at one point when Attorney Miner makes mention of
Yes,
that. And I don't know what we're doing with that yet, but
okay,
putting that to the side, I don't think that what you just said about windows is the same thing as I'm saying about being on an electronic bracelet.
okay, okay. Because
I think there's different prejudice that attaches to those two things. The fact that he had restrictions, that he was on federal supervised release, and that he had some restrictions is going to be known to the jury. It's integral to the case. But the fact that he's on an electronic monitoring bracelet is a different thing
Okay,
in my mind.
thank you, Your Honor. I understand your rule.
But keep on objecting, as I know you will. But that's sort of the dividing line that I'm drawing in my mind's eye right now.
That's a big win for the defense. That motion was to exclude any evidence. Hold on a second. Number 12, to admit, that was the Commonwealth's motion in limine to admit evidence concerning defendant's federal charges, and she's denied that. So the jury's not going to hear about his federal charges from what I heard. I'd have to go back and look at the papers, and they're also not going to hear that he was on a GPS monitor, that he had an ankle monitor on at the time. That's what it seems to me that she just said. I'm going to have to listen to it again. Somebody keeps asking if Proctor complete the fifth. He can, and he probably should have at Karen Read's trial, but he didn't. But, you know, we'll see what happens with that. There's also some confusion about Laura McLaughlin being in the courtroom. She's not there. That is not Laura McLaughlin in the courtroom. That is Greg Connor, all the way on the right. He's the attorney that I think has the most integrity at the Norfolk DA's office. He's the one who told the world and everyone that he was going to be releasing Proctor's phone extraction to third-party law enforcement agencies, and he did, and that is what led to Sergeant Sean Good's suspension from Canton PD. With Greg Connor today are ADAs Ann Yaz, Y-A-S, and Tracy Cusick. Laura McLaughlin was on this case. She does not seem to be any longer because she has not been in the last couple of hearings. She was in the hearing where Judge Freniere cornered her and said, I'm sorry, but weren't you also on the Karen Read case? So don't you already know what's in Proctor's phone extraction in the federal 2E materials? So shouldn't you know whether there's anything related to the BRIAN WALSHE case? And she was like, And I don't know if we've seen her since. I don't know if we've seen Laura McLaughlin since. So I don't think she's on the case anymore, but I'll find out.
And keep on working on the stipulation.
Yes, Your Honor.
Paper number 199 is Commonwealth's motion in limine number 13. It's to admit the victim's out-of-court statements, evidence of her state of mind, and the defendant's motive to kill her. Defendant is opposing it in part. I'll hear from the Commonwealth first.
Thank you, Your Honor. The Commonwealth would seek to introduce the victim's out-of-court statements to Alyssa Kirby and to Mr. Mutlu and to Mr. Fastow as to her state of mind, which was known to the defendant. Your Honor, certainly the defendant, the evidence will show that the victim had a meeting with a friend, Ms. Kirby, on the 29th of December and told her about the big argument they had had over Christmas.
Give me a timeline because I want to have this in my head. She comes home on Christmas Day.
Yes.
Ana comes home on Christmas Day. She drives because she missed the flight. She spends much of the day driving, and then she gets there on the afternoon, evening of the 25th.
Yes, Your Honor. I believe it'd be around 8 o'clock.
When did she drive back?
She leaves on the 26th of December.
Okay. And she drove back to DC.
And she drove back to DC
And then she returns back to Boston by flight on the 30th.
on the 30th.
When people say she wouldn't leave her children, I point to this, okay? She claims her flight was canceled on Christmas Eve. She drives to Boston for Christmas Day. Clearly, she's not even there when her kids are opening their Christmas presents early in the morning like they do. Because if you ever have little kids, they were 2, 4, and 6. They wake up wicked early for Santa, and they get down there before the sun comes up to open their gifts. So she wasn't there for that. She drives home. She gets home Christmas night, and then she leaves again on the 26th. So just, just think about that. Yeah, Law Tubes Most Hated Mod, Scott, 25 years, NYPD, says they also should have pulled her Easy Pass or GPS records from her car. Yes, agree. She had a boyfriend in DC. We know that. So I want to hear that again. Taking it back. Because I want to hear the timeline. Now, we didn't know this timeline before. It has not been in any of the papers. And they want to use the big argument that Ana told Mutlu about as motive for BRIAN WALSHE's allegedly killing her.
It's in my head. She comes home on Christmas Day.
Yes.
Ana comes home on Christmas Day. She drives because she missed the flight. She spends much of the day driving, and then she gets there on the afternoon, evening of the 25th.
Yes, Your Honor. I believe it'd be around 8 o'clock.
When did she drive back?
She leaves on the 26th of December.
Okay. And she drove back to DC.
And she drove back to DC
And then she returns back to Boston by flight on the 30th.
on the 30th.
All right, that's helpful. All right, go ahead.
Your Honor, on the 29th, when she's still in DC, the night before her return to Boston, she goes out to dinner with her friend Alyssa Kirby and talks about the big fight that she and the defendant had, and tells Alyssa Kirby.
She'd been home for Christmas.
Yes, over the Christmas break, or the day that she was home. She tells her about that big fight, that she gave the defendant an ultimatum, that she had learned that the reason the children weren't with her was because of the defendant and his attorney, and that she had told him essentially to just resolve the case, even if it meant taking jail as a result. And I know Your Honor has reviewed the paperwork, and it is a little more detailed, some of the statements at grand jury. Your Honor, I would suggest that this is admissible because certainly it shows the victim's state of mind, that she is prepared to do what she needs to do to take her children down to DC to be with her. She had a very highly compensated job, and I know Your Honor is familiar with the circumstances of her moving to DC without the defendant and the children. I suggest that that is certainly known to the defendant. He acknowledged and alluded to a big fight over Christmas in the recorded interviews, and indeed said that he had learned after fighting with the victim previously over Christmas, and I believe he said Thanksgiving, that he was not going to fight with her over her alleged need to return to Washington, D.C. for a work emergency. Suggests this is highly probative of the victim's state of mind and the defendant's motive to kill her. It also shows that he is aware of this. He's searching Mr. Fastow's name. He's searching for divorce. And he is conducting those searches in between. I believe the search for Mr. Fastow was on December 25th. And then he's searching for divorce, I believe, on the 27th. His mother then hires the private investigator to investigate Ana's, whether she's behaving appropriately for a married woman. That's on the 28th. Certainly suggests that all of this is highly relevant to the victim's state of mind and the defendant's motive to kill her and what happened in that home on the 1st of January. And with Mr. Mutlu, there is some testimony about Ana Walshe had some conversations with him, I believe, on the 28th. And Mr. Mutlu's testimony is a bit indicating in some of his statements that some of it he might have learned from other people, but some of it he did learn from Ana. And certainly the Commonwealth would be very careful to make sure that we were only eliciting what he learned from Ana, not something he had heard from somebody else. And I suggest that that should all be admitted in this case.
All right. Defense?
Thank you, Judge. Your Honor, the problem I have is the Commonwealth is also cherry-picking parts of these conversations. The dinner that they're speaking about, her and her friend were out until 1:30 in the morning, a night that ended at a karaoke bar. So there was probably copious amounts of alcohol, I would assume.
But that goes to the weight the jury chooses to give to it.
But in the context, I think it's important. The other thing that the Commonwealth didn't seek to introduce is the fact that Alyssa Kirby at the grand jury, at her grand jury testimony said that they had a very open and honest relationship and that Ana wanted him to do whatever he had to do so the family could be together. And further, she didn't say that she wanted a divorce or was going to leave him with this ultimatum. Specifically, Ana supposedly said to Alyssa Kirby that she wanted him to choose life because he had been so depressed. And even if he had to go to jail, that will be waiting for you when you get out.
Mm-hmm.
So I think they're not only cherry picking what portions of this conversation they want to put in, they're overstating the relevance, especially in light of the case law. When you look at the cases that talk about state of mind, they cite Castano. That was a situation in which the witness had told the defendant in that case that she wanted to end the relationship, that she had rejected his anniversary presents, not only was ending the relationship, but has packed up his bags. And when the police responded to the scene, there was in fact a packed suitcase of the defendant's items at the door. That is not what we have here, let alone to that level. In Martin, the statements that the government was seeking to introduce were basically statements in history of physical abuse, violence, of her trying to take the children from him. That is not what we have here. Half of the conversation to Miss Kirby was how she wanted her family together. They had an open relationship. Couples fight. So to say they had a big fight on a date, she was late for Christmas and they had 3 children. This was not earth-shattering motive to kill information. So I don't think it's fair that these conversations with Alyssa Kirby come in. And certainly if the court does see value in those statements as the case develops, then the doctrine of verbal completeness would force the court to allow all those statements to come in, because this was one conversation. So that would be our position with respect to Alyssa Kirby. With respect to Jem, I think there needs to be either a voir dire or some clearing up of what he heard from other witnesses and what he specifically heard from Ana. And again, Mr. Mutlow was with them on New Year's Eve into the 1st of January until about 1:30 in the morning. And he's also described the night is joyous, that they had a happy marriage. The federal case had been going on since 2018. They had been weathering this storm. And so again, if they're seeking to introduce statements, I think that the full conversation would come in to show the context, and we need to figure out what exactly Mr. Mutlow heard directly from Ana.
All right. So let me give you some guideposts. The defense in its opposition cites to Qualls, which is sort of one of the earlier and seminal cases on state of mind evidence. And but not persuaded by the defense's argument with regard to what qual stands for in light of Castano and in light of, which for the record, Castano's at 478 Mass 75, a 2017 case, and also look at Commonwealth versus Bins, B-I-N-S. That can be found at 465 Mass 348, a 2013 case at head notes 17 through 22. Under that case law and other cases that I looked at, it is very likely that I'm going to allow Ana Walshe's statements to Alyssa Kirby, a limited purpose of establishing her state of mind as is relevant to the defendant's motive to kill his wife, to the extent that such state of mind evidence includes statements describing his defendant's prior bad acts. His federal case on his statements will be admitted, and with a limiting instruction that it is limited to show the defendant's motive and not to show that he had a bad character or propensity to commit any other criminal offenses. There's a limiting instruction that is posited by the court, the SJC and Bins, on the bottom of top of page 419. Take a look at it. That's what I'm likely going to give you. I think that the parties need to do a little bit more work with Jem, and they will, as the Commonwealth gets ready to prep him for his trial testimony, and obviously be in touch with the defense with regard to what that pretrial work reveals with regard to statements that were made directly to him from Ana, as opposed to third-party other evidence that would not be admissible.
Yes, Your Honor.
With respect to William Fasto, there's one notable exclusion or sustained you're going to hear.
William Fasto is Halava from Washington, D.C., who sold them that Washington, D.C. condo. That is William Fasto.
Sustained you're going to hear. Exclusion or sustained you're going to hear. The statement that she makes to Mr. Fasto about she doesn't know what the defendant would do if he were to find out about the affair is not her state of mind evidence and is not admissible and is prejudicial. So don't go there.
Yes, Your Honor.
And then, of course, with regard to the doctrine of completeness, I think the defense has an argument there. And so I'm inclined to let them bring in the other statements. And you can oppose it if you want, but that's sort of the guidepost that I'm setting right now.
Understood.
All right. Paper number 200 is Commonwealth 14, to allow the admission of text messages conversation as of 11/12. I wrote the defendant had not filed a written objection. I think I invited that at our last hearing, and I'm guessing that you didn't because it's 801D2 stuff, but you let me know if it's otherwise.
So, Your Honor, with respect to the text messages, I think maybe we have some objections to some of the portions of the text messages, but specifically, and I did talk about this in
Another paper?
defendant's response to Commonwealth motion in Lim 13. The William Fasto text messages, I don't think that any of them are admissible and the jury should not receive them. There is no evidence about state of mind in them. It's text messages about two friends who are having an illicit sexual romantic affair. There's no evidence by the government other than speculation that Mr. Walsh ever even saw these messages.
Is it speculation? I mean, he says in his own words in the interview that somehow her text messages are showing up on my phone or something to that. And I'll go back and listen specifically, but we did cross this issue once before, and that was my recollection. Maybe it's a failed recollection.
No, the statement that you're referring to, there is a conversation between Mr. Walsh and the police where In the same paragraph, he says, iMessenger, not iMessage. And then there's talk of Facebook messages popping up on its phone. So I don't think it's clear. And even if the court were to infer that iMessages came to his phone, there's no indication that those came to his phone.
That's right.
The text messages with Ana Walshe and Will Fasto ended at about 10:30 on New Year's Eve. Mr. Mutlow was at the home until 1:30. He specifically said, either during an interview or his grand jury, that at no point did he see Mr. Walshe on his phone. He didn't see Mr. Walshe on his wife's phone. He, again, described jovial, happy, up until the time he left at 1:30. So I think it's a very thin speculation that he saw these messages. If a foundation is laid during trial that indicates that he did see them or he did know them, it would be different. But otherwise, these text messages are hearsay and they're not admissible for any purpose.
How are they hearsay? In order, in what I'm focusing on is what in them, is to prove the truth of the matter asserted.
Well, then
I guess we'll have to look at each, and that's sort of where we're going to end up with the transcript, I suspect.
Well, then that's it. So it kind of reverses the question back to the government. Why are they seeking to put this text message history in? They're putting it in because they want to wave it around and say she was having an affair and he knew and he killed her. That's what they want to do. And I think if there was actual evidence or proof, other than speculation, that he had seen these messages, was angry about them, we'd be in a different posture. But that is not the case. And so why are they trying to put them in? And hearsay, her messages, her statements are hearsay. So what other purpose is it coming in for? I don't see a purpose other than to just wave this in front of the jury. Mr. Fastow is going to testify. He can certainly testify to the relationship between him and Ana, the duration, the time, but those text messages should not go in front of the jury.
All right. Kamal.
Please.
Your Honor, in addition to the defendant making statements about her iMessenger appearing on his phone, he also told the police that her phone was upstairs on New Year's Eve. He told police about some quarrel she had had with someone over text message and then had been put her phone upstairs in their bedroom.
Abdullah.
Yes. That's different than Mr. Mutlow's testimony that she was using her phone all night. So I suggest that's certainly.
Let me ask you this. Based on the forensic work done on the defendant's phone, is there any evidence that he was on his phone that night?
No, Your Honor, there's not.
Okay.
That's the phone that was
Missing.
misplaced.
Right, but you do have evidence, this has been the subject of other motions, that on the first and into the second, that there was some manipulation of that phone to unlock it. So I guess what I asked you, and it was a sort of a void in my mind of whether there was any evidence that he was on his phone on the 31st, and the answer to that is no.
The first time his phone was manipulated was at, I believe, 7:35.
In the morning of the 1st. All right, just trying to get the facts in my head. Well, more to follow on this as to individual text messages, and I want you to be focused on whether or not they are being offered for the truth of the matter asserted, and if they are, what your positions are, and see if you can make some headway on this.
Thank you, Your Honor.
I like that the judge seems to know all the facts. She's read all the papers. She's very well versed in the case, which is more than we can say for Judge Cannone, because at one point she didn't even remember that BRIAN Higgins had testified in the trial. Remember that? I do. There was some pre-trial discussion, and we've been over most of the motions in this case, and there were many statements that were recorded by the Massachusetts State Police troopers, including Proctor and Bukhenik, assigned to this case, in which BRIAN Walshe said during at least one of them that sometimes Ana's, and now they're saying it differently, iMessenger messages would show up on his phone. Now, Facebook has a messenger application, you know that, right? So are they talking about Facebook Messenger messages or iMessage text messages? Those are two different things, I would submit to you. And so I don't know how Ana communicated with her lover, Mr. Fastow, but perhaps we will find out. And she's not really making a ruling on this yet. We're going to have to wait and see on a message by message basis, which I think is the good way to decide this right now. And also remember, as we've seen many times in Massachusetts cases, specifically Karen Read, they can always voir dire the witness before they testify to find out what they're going to say, and she can rule on it then. So sometimes it's a game time decision.
Oh, Your Honor, the only other thing with respect to the messages, and this could be an email instead of, I just wanted to, we can certainly check, but if I could have the government verify if the messages they are proposing to introduce between Mr. Walsh and the other witnesses, if they have been edited at all, because we have like pages of text messages over a couple days to various witnesses, and I don't know if that is just the chunk that they are taking, or if they went in and cut out any messages.
Okay. And by the way,
I'll talk to the council afterwards.
Okay.
by the way, this motion that I'm talking about, we started to talk about Mr. Fastow and Ana Walsh's text messages. But to the extent that they're the defendant's text messages, which were the subject of this, then that's in a different bucket in terms of evidentiary ruling. Maybe not as important to you either, which is why you went to the other.
Right.
Okay. Commonwealth number 15 is to admit internet history from devices in the defendant's residence.
Your Honor, the government has produced 2 binders that they expect to introduce into evidence. One is a binder of the gray MacBook, and then the other one is a binder of, I only have 2. Are you gonna? Oh, okay, we have 3 now.
All right.
So we appreciate that.
Are these for my own, sorry to interrupt you, but are these similar, if not the same, from what came into grand jury?
They're not the same to what came into grand jury.
Okay, because I'm familiar with those from the prior briefings.
This is significantly more material than what came into the grand jury.
Okay. Is it the same sort of format, though? There's a search and then the result of the search?
No, Your Honor, this would, I would suggest, be from a Celebrate report, and we have copies here that we can give to the court to review.
Okay.
But the Celebrate report for the MacBook pulls from 2 different databases, so you see the same search twice or the same visitation twice.
So let me ask you this. I have some questions that I need to process in my head.
Yes.
The searches that are done, is there forensic evidence that shows that the searches were done on the MacBook Pro
Yes.
and not on the iPad?
Yes.
All right. That's what I suspected, but I haven't asked and nobody told me that. I assumed that that was the case.
Yes.
Because that was not the state of the evidence, as you know, at the time the case was indicted.
Yes, Your Honor.
But is Celebrate really accurate? Because the Commonwealth had us believe in the Karen Read trial that Celebrate's not accurate and that the timestamps absolutely are not accurate because the timestamps refer to the last time or the first time that you ever opened that window. And so I hope that Larry Tipton and Kelly Porges are on top of this, and Kelly Porges has spoken the most at this hearing and she seems really on top of things. And so, maybe they should call Ian Whiffen in to talk about how Celebrate timestamps are not accurate and Celebrate took away their timestamps. And so Greg Connor has 3 binders full of internet searches that they want to introduce the internet history of all the devices in the Walsh residence and show them to the jury. And I submit to you that it's prejudicial because if the extraction comes up as having searched twice for the same thing, but it was really only 1 search, that seems to be a little bit prejudicial in my opinion, but we'll see what the judge has to say about that.
As you know, at the time the case was indicted.
Yes, Your Honor.
So, and from that time, and that is March of 2023 when the case was indicted, are you saying that the forensic work has uncovered additional searches beyond what was known at that time?
Yes, Your Honor.
Okay, and what's the volume of that?
So the MacBook report, that report that was generated is approximately 1,000 pages long.
Okay. Is that where this search I hate to be so graphic, but well, it's not that, this isn't that graphic, but this, in paper number 201, I learned of a search that I had never seen before, which is
We're objecting to that one.
right,
Tell us
Okay.
what it is.
so that was not part of the grand jury.
It was not part of the grand jury.
What is the date of that search?
That is, I believe, forgive me because there's so many, but I believe it's in and around Christmas.
So it's
It's before.
Pre-
Before.
January 1st.
Yes.
Is it around the same time as the divorcing?
Yes, Your Honor.
Around the 27th?
If I may, I have a cheat sheet for myself.
Go ahead, cheat.
It's
Greg.
1227, Your Honor.
Everybody else in
And,
your office does.
it is approximately 8 hours before the searches for divorce.
So, Your Honor, there were more searches and hits in general on this topic, as you might see on someone's device. This particular search, the name was, I'm trying to be, it was also about having a threesome and impregnating someone. There's multiple searches
Oh.
for porn. He is an adult male. So
Oh, that's right. It's the corn searches. The corn search is about a man whose wife is having an affair and watching or something such as like that.
I think to just cherry pick this one, and
I don't care about the porn part, so to speak. I mean, that is the, it's inflammatory, but it's the second part of that search, cheating wife. So that goes to the issue that we just talked about before, about his state of knowledge and what reasonable inferences can be drawn from that search being done on the 27th. That goes to that is an argument with regard to his state of knowledge on the 27th as to whether or not his wife was having an affair. Right?
Right, but it was
I could
cheating
care less
wife-
about the,
It was cheating wife corn, wasn't it? I have to say corn on YouTube. It's cheating wife corn. He wasn't just Googling how to tell if your wife is cheating, right? It was cheating wife corn.
one part of it.
no, I understand. I think, but without getting into a semantical discussion about pornography, I think that there's millions of different interests, predilections of what people might
Sure.
watch or like, and I think that it wasn't just cheating wife. It was cheating wife has threesome and gets impregnated. So to say that could have been ancillary to what the content of the material was. So I think it's inflammatory. So when the
Right.
court,
So there's this body of evidence of searches now that are not in my mind because and it's not that it's inappropriate. That's why we have these hearings. But what would be,
Okay, that was not on my bingo card. Cheating wife, threesome and gets impregnated. But this is a slippery slope, and just excuse the pun. But if we start judging people on their corn searches as evidence that they would then do such a thing and or commit murder because of such a thing, that is a very slippery slope to go down, in my opinion. Tell me what you think, but be very creative in the way that you spell things and phrase things in the chat, please. Thank you.
be helpful to me is if the Commonwealth, A, can provide me with those searches, and B, if you know, and it's not too much additional work, identify, and maybe it will become apparent to me because there's only the list of what you knew at the time of grand jury is pretty much encapsulated both in the grand jury transcripts, but also in the affidavits.
Your Honor, we're prepared to give you the binders and a list of the items that we would seek to elicit at trial from the binders.
All right.
And we'd give that, of course, we've given the binders to counsel, but whatever we give to the court, we give to counsel.
And then if there are particularized searches that the defense is objecting to, I know you will raise them with me. And as a matter of logistics for how the jury is going to be presented this is even the stuff from grand jury, which I printed out because I'm still old school, is binders worth of materials that I have still with me. How are you going to present this to the jury?
So, Your Honor, we have, that would be tagged as an exhibit, a binder, but then it can be
View.
broadcast on these different monitors. So we can ask the witness about a certain entry in the report and put the entry on the screen, and then have the witness testify from the screen saying, this is what occurred in this entry, according to the report.
All right. Just an awful lot of material for them to absorb.
We understand that. It's also important material to the
I
Commonwealth's case.
understand.
And so it's not an easy examination, but we do believe that it's important, and we've tried to make it as streamlined as we can.
How about, I don't know, how about like actual forensic evidence? Right? Mark G says, I'd stay with the real evidence, saws, bags, cleaning supplies. I mean, if you're going to convict someone based on Google searches, binders full of Google searches. Yeah, who's going to testify to them? Guarino or Keefe? Connor Keefe, I think, is the one who did the extraction, and then he went home and he left the phone and the iPad hooked up and left them there overnight unattended. He testified to that at the evidentiary hearing. And they want the jury to dislike him. And in my opinion, those Google searches that don't have to do with the things like how to dispose of a woman's body if you really need to, or best tool for dismemberment, are more prejudicial than probative. And they want the jury to dislike him, says Courtney. And I agree.
All right.
So, Your Honor, too, just so the court is clear, I believe the government's position is that they're going to put in 3 or 4 actual binders into evidence. So the jury is going to get a giant binder of 1,000 pages. And so at what point does that become cumulative and prejudicial when they just drop by? And I'm just trying, is there a way to streamline this, or is there a way to cull some of it? Maybe that's something we can all work on. I just wanted the court to be aware that that is the intention.
More to follow.
More to follow.
The sirens.
All right. Paper number 16, to introduce Axios Investigations, hired by Ana Walshe, December 28th, 2022. Defendant is opposing. So
That's the private investigator that BRIAN WALSHE's mother hired on December 28th, 2022 to do surveillance of Ana Walshe because BRIAN's mom thought that Ana was cheating on him.
what is it? Is the Commonwealth just seeking to admit through a person presumably that comes from Axios, because Ana Walshe is not on the witness list?
Yes, Your Honor.
So
We listed her as a witness, Your Honor. We don't know if we're going to call her, but we did list her in an abundance of caution.
all right, I'll make sure that she's,
I apologize, Your
I
Honor.
don't think she's on there.
It
She's
could
not
be a
on the list.
clerical error, but
Okay, so keep that, so
She's
that,
also present in the court right now, Your Honor.
Oh, she's in the courtroom. Mama Walshe is in the
Well-
courtroom.
do you want to do anything about that?
I didn't know she was on the witness list, so I didn't move to, I didn't move to sequester her for this hearing. So I didn't understand that she was going to testify, Your Honor. I apologize.
All right, so,
I can tell you what I would intend to introduce at trial from Axios. It's just very simple, a contract that was executed.
right, which I've seen.
Yes,
It's a grand jury exhibit.
yes, Your Honor.
What's the objection to that?
so, Your Honor, what's the relevance of someone who the government isn't calling as a witness to introduce something that they did on the 27th of December?
Well, the relevance, and frankly, I'm going to ask that Ms. Walsh leave the courtroom.
Thank you, Your
Mama
Honor.
Walshe. Gotta go now. Brian,
speak
wave
more
bye-bye to
freely.
mommy.
Mhm. Thank you.
Well, she can't stay if she's going to be a witness because they don't want her to, get a heads up on what her testimony can or
So,
can't be.
Your Honor, the evidence that the government has provided us suggests that Diana Walshe contacted Axios Investigations on December 27th through email and phone calls, that she signed the contract, that she paid for it. In the grand jury testimony, Jeremy Dozier states that Diana Walshe specifically said, "I don't want my son to know about this." So they're trying to basically say, she did this. We have no evidence that he was part of it, knew about it, directed it, paid for it, and it's just prejudicial and
But there,
offended.
I read somewhere, and it has to be in the grand jury, I read somewhere that the connection to the defendant is that she wanted to do this for some time because of the psychic, and that she went to the defendant or said to the defendant, "I want to do this," and that he
Psychic was not on my bingo card.
tried to rebuff her and say, "No, I think his words were, Anna's a good girl, and, she's not having an affair," something to that effect. But then I also read somewhere, it has to be, again, in the grand jury, that he then gave her the name of Axios. So even though he said, "Don't do it," he gave her the name of the company that she hired, right?
So if the government is going to elicit that information,
That, the only way that comes in is through Diana Walshe.
and they did not list her as a witness. So even if
will
there
now.
was evidence that the government was planning to introduce, that Mr. Walsh supplied the name, that doesn't indicate he paid for it, knew that she finally did it, was interested in the results. The evidence we do have is that the mother saw a psychic, and even the the evidence suggests that when Mr. Walsh was speaking to other people about it, he was dismissive of it and even told his wife about it. So I don't think it's appropriate that they get to introduce the contract or the fact that Diana Walshe hired a private investigator on the 27th, unless they're going to call a witness to link it to him and that he knew about it, wanted it, and was invested in the results. Otherwise, it's not relevant.
So, Your Honor, you were right about your memory of the grand jury testimony. That statement of the defendant giving the name Axios, that comes from his mother. So
But you don't have her on the witness list, so how do you make that connection without her?
that's fair. We were suggesting as a reasonable inference by the amount of contact the two of them had, and that he saw her
No.
frequently, and that he talked to her frequently over the phone. But again, we were trying to be very limited with what we were entering. It was just the contract through the private investigator. So with that, I think Ms. Porges, her assessment of the evidence is correct. And so I don't want to belabor this issue. That was the only thing we were trying to get. We're not trying to get any statements of the defendant, nor were we trying to get any statements of his mother, simply the contract.
Well, you make whatever strategic decisions you're going to make, but that may lead for a paucity of evidence on linking his knowledge to it. That's your choice.
Understood, Your Honor.
All right.
Why don't we
Number 17 is paper number 203, and no objections to the calendar.
There isn't, Your Honor, but given the fact that my understanding is that there's going to be a blank calendar and items or notations may be placed on it, and I'm assuming then that is going to go to the jury. If that's the case, then the defendant would also like access to also add or denote things on that calendar, and we can color code it, we can figure out a way, but that's what I would ask for. Or we can have two calendars, which seems superfluous if there's one.
We were just looking to give each juror an empty calendar so they could make their own notes and it would be part of their notebook, not something like that witnesses would be using.
So if
Okay.
they just want to give a blank calendar to the jurors so they can keep track of days, then that's fine.
Yeah, it just got confusing during the grand jury.
All right. 206 is allowed, sequestration of witnesses. 207 is a review. Commonwealth took no position.
Your Honor, may we be heard sidebar?
Yes.
They want a view of the house on Chief Justice Cushing Highway, but the issue is that was a rental for them and someone else is probably living in that house now. So I don't know how they're going to get around that unless the current owner and tenant is going to allow them a view. We have a little room to scooch here. around this sidebar about the field trip that they want to take the jury on to go see the home in which Ana Walshe was allegedly murdered and then dismembered allegedly in the basement, I believe. That's going to be their theory. Where's Lady Zelda when you need her?
With permission, is it okay if Ms. Walsh comes back in?
No objection.
Sure.
Thank you.
Brian wants mama back in the courtroom. It's the only moral support he has.
So paper number 208, which is now we're moving to, did move at paper number 206 to the defense's motions eliminate. Paper number 208 is defense number 3. That is now mooted and requires no ruling. Paper number 209, defense 4.
Defendant's motion in limine number 3 was regarding evidence that the biological evidence is bone, and we went over that motion in limine from the defense. They said there's never been any evidence that what they found was human bone or animal bone. She's saying that is moot, so I have to assume that the Commonwealth agreed that they're not going to introduce any evidence of that alleged bone found on the hacksaw in the dumpster, which is a very interesting development, unless they provided evidence that it was actually bone, but I don't see any evidence of that in the record that I'm looking at in the docket. So that is interesting. So many people have been saying he's absolutely guilty because they found her bone on the hacksaw in the dumpster. It seems to be that motion is moot.
Commonwealth has indicated they will not seek such opinion, so no ruling is needed.
Wait, I gotta go back 1 second. Why are they showing Mrs. Walsh on camera? Like, leave her alone.
And requires no ruling. Paper number 209, defense 4. Commonwealth has indicated they will not seek such opinion, so no ruling.
Another interesting development. That motion, number 209, was regarding Cappizzoli's opinions regarding the damages on the lawsuit. Remember, the landlord of the Chief Justice Cushing Highway home that Mrs. Walsh, Diana Walsh, signed a lease so that they could rent that home, the Walshes, Brian and Ana. That landlord, Cappizzoli, sued Mrs. Walsh, because she's the one who signed the lease, for all of the damages caused by the police in executing their search warrants. And he said he had to have tons of cleanup done and there was stuff everywhere and he had to clean it up. That is another very interesting development because in my opinion, that could have been damaging for the defense. But now the Commonwealth has said they're not going to introduce any of that evidence. Interesting.
Ruling is needed. Paper number 210, defense number 5. Commonwealth will not seek, no ruling is necessary.
Your Honor,
Mm-hmm.
might we ask that a similar order regarding any awards or commendations for any defense experts that may be called? That they may not elicit that from those experts?
Well, to the extent that it goes to their qualifications,
Right.
They need to do that. They need to know that the person's qualified, but no excessive lauding. How about we say that? On either side. Paper number 6, defense's motion in limine regarding any opinion that the defendant knew about the extramarital affair. And that was opposed by the Commonwealth at paper number 230. And as I understand the respective positions of the parties, is the Commonwealth's position is it's not seeking an opinion as to that, but is going to plant breadcrumbs such that a jury could or could not, but they're hoping they could infer the same.
That's right, Judge. They've told us they're not eliciting an opinion, so that
Right.
answers that.
So that seems to be the line that the rules of evidence draw as well. Paper number 7, defense number 7. What did I write here? Is paper number 212, and it's regarding opinion evidence, and the opposition was at 231. And I wrote to myself, what more do you want? And under what authority?
Well, all I'm trying to do, Judge, and all we're trying to do is keep these witnesses from taking the stand and start offering opinions as opposed to the facts of their investigation, that they not be asked opinions that they have not provided in all of these reports. Because when you read through the hundreds of pages, and what they've given us is all this search data and everything, that's fine. But they can't then elicit, do you have an opinion about what this means? They can't do that, and that's why we filed this motion. That's all.
I'll hear from the Commonwealth.
Thank you, Your Honor. Your Honor, we've provided voluminous discovery in this case. Certainly, we expect that the witnesses will testify as to what they did in conformance with their reports. They'll explain their reports to some extent, but the defendant has all this material that has all been provided. So we would, if there's something specific they're looking for, but again, the witnesses will not stray beyond the reports that have been provided.
All right, then we have no disagreement. As an aside, by the way, it is somewhat surprising to me as I was looking at this issue, how little is said about experts in the context of, or how little is required by the rules in stark comparison to the civil rules. And I can't resolve that in my mind, why the drafters of these rules sort of make a heavier burden on the parties in a civil case with regard to expert testimony than is expected in a criminal case. I don't know why. Curious.
If I may?
Yes.
I suspect it's because in criminal cases, you have procedural due process bumping up against substantive due process, and that's not present.
Wouldn't you think that would then err to the side of more disclosure for the defendant?
I think less, because fair trial strategy, and that might be different. That would be my thought.
My thought when I was sitting in the back is, why don't they have to produce what they have to produce in a civil case? But I don't write those rules. I just try to interpret them.
I don't want to belabor this point at all, but I remember Stephanie Page filing motions for depositions because you allowed depositions in civil cases.
Right.
And we were always shut down saying no, and we asked the same question the court's asking.
Well, I'm asking that question, and I almost never allow depositions in a civil case, even of the experts, but
That's a great point,
regardless.
Matt says,
It's just,
is this why the judge doesn't understand how to suppress illegal searches? Is she better with civil law? I think she just answered your question.
curiosity. Anyway, defense number 8, paper number 213, opposed at 232, and then another rebuttal at 281. To exclude defendant's request to consult with an attorney or statements of prior counsel. And I got more on that today, I think, too. Let's pause on that one. Bad Acts 214, paper number 9 for the defense. I think we've discussed this. It's opposed by the Commonwealth in a partial opposition at paper 233. And I had written to myself in my notes, question to the defendant specifically, what additional statements from the recorded interview does he want to exclude? But we're going to get to that in a minute. Paper number 215, defense number 10, motion in limine regarding witness characterization of evidence or of the defendant's behavior. The Commonwealth has said it will not seek character evidence, but will offer evidence of the defendant's behavior through observations. Is that right?
Yes, Your Honor.
All right, that seems reasonable. and likely where the line's going to be drawn. Number 11, paper number 216, asking the Commonwealth to designate and provide notice of specific statements and internet searches contained in the digital data seized to be introduced at trial.
In the 3 binders worth of searches.
Anyone wish to be heard more on that issue?
Your Honor, the Commonwealth did file a responsive pleading, paper 234.
I saw that. I will say that the Commonwealth's opposition at 234 seemed to take a reasonable approach. And likely where the line will be drawn. Is the pillowcase and the pillow, that's all over, right? There's nothing there.
We're not going to introduce it, Your Honor.
And there's nothing other happened with regard to this is just a hanging, dangling from the prior motions, the dinosaur, teddy bear, that's nothing I need to worry about.
Nothing you need to work on. We sent counsel a list of photos we were intending to introduce. I think that we cropped out any images like that. And so if there's any issues, they'll let us know.
All right. So how do we take on this, what the remaining issue that I really want to address today, and then I'm happy to talk to you about anything that you need to discuss with the court, is these transcripts. And I had about 5 minutes to look at the case that the Commonwealth has now cited in its most recent briefing of this morning, and I want to give it a closer look. But one way that we can approach this is to literally go line by line. I know that the defense has indicated, and I appreciate the way that this was laid out in the briefing.
All right. When she says transcripts, is she referring to the binders full of Google searches? Because that's not, I don't think transcript. When I think that, I think extraction. But I think that's what she's talking about. Let's see.
Because it makes it very clear as to what it is that you're seeking.
Oh.
And helpful. So I
I
appreciate.
think it's transcripts of his statements that he gave to law enforcement, but let's listen.
The work that you did to get that in that shape. And you've stated your objections. So one way I could do this is to just go through on this list that you gave to me and rule at some time between now and before the evidence is played, and give you a little bit more time to brief it. I will say that as I said to you at the side of the bench on Friday, but I think that there's a evidentiary issue that needs to be decided with regard to what the scope of the employment of Miss Miner was. And I'm not sure how this new law.
Ms. Miner, Tracy Miner was Brian Walsh's attorney for his criminal federal case for the selling of the Andy Warhol paintings. And she was present with him during a couple of those interviews. And so some of the statements that she made, the defense and or the Commonwealth wants those statements made by Tracy Miner to be redacted from any statements. And so that is what the judge is discussing now.
Fits within that, what the scope of the employment of Miss Miner was. And I'm not sure how this new law fits within that analysis. If it does, if it's just a separate analysis, it almost seems like it's a separate thing completely. And a separate vehicle or avenue to admissibility, these adopted admissions. But I want to give the defense time to respond to that because it just came in this morning. And as to many of these statements, and so that you don't misunderstand where I thought I was on Friday, which was alerting you to the issue of agency, I'll call it. And I don't want either of the parties to be misguided by what I said to you on the side of the bench with regard to that. And what I mean by that is this. Even if Attorney Miner's statements aren't coming in, even if they weren't coming in, I never intended to not allow the Commonwealth to tell the jury that she was present there. So whether her statements come in is very different than whether her attendance at the interview was going to come in. And I think in the opposition that I saw, the papers that I saw flying, I think the Commonwealth, maybe based on what I said at the side of the bench on Friday, thought that I was excluding the latter as well. That is, her attendance at the interview. I also want to remind you of something that I said at the side of the bench on Friday, which is much of what Attorney Miner says is repeated by the defendant. And so the cumulative impact of those statements is not significant for the most part. There may be statements that she makes that are significant. It seems to me, and I'm sure the defendant is going to ask for the humane practices instruction. And if that is the case, it would seem to me that the dynamic of what is going on in that home during those interviews is relevant to that, specifically Thomas's role. I see you nodding your head no, but then I get to the later interviews. Maybe there's not enough in there for you to care about it. So why are you nodding your head no over there, Attorney Tipton?
I appreciate the time to respond. I was reading their cases at 4 a.m. That's not the best time to be reading cases. If the court...
I was blissfully ignorant of it at 4 a.m. I didn't see it until 7 a.m.
So if the courts, we will file a...
Defense attorneys do not sleep when their client is facing life in prison. So there's that.
written response. My understanding is this court's going to give us time for that. And when's a good time to have that filed? You said you would make a ruling before the evidence started, so I'm
Right.
just wondering.
I mean, honestly, the next couple of days, we're going to be busy with picking a jury and maybe even longer than that. So, I mean, I don't, as long as I rule on it. Yeah, as long as I rule on it in time for you to make the appropriate edits and I don't ruin, you know, the poor IT person that's going to be tasked with doing the edits Thanksgiving. How deep into the case are these transcripts coming in?
Potentially the first day, Your Honor.
Well, great, thanks.
But the good news is like you said, a lot of it was cumulative. And so in going over that, particularly the interview in the 7th, when we looked at it, we're like, there's really not a big problem with a lot of these. So we'll start working on some of those redactions. And we gave a list to the court of the things that we didn't object to. So we're going to start working on this.
So curiously, and I just want to make sure that this was a conscious decision on the defense's part and not something that was unconscious. There's some of what she said that you kept in. You know that. Well, attorney,
No,
there are some statements that you did not ask to be, and so,
from Tracy Miner, Judge?
yes.
Well, then that was an error. That's the highlight, didn't carry through.
Okay, all right.
Because, and I don't want to interrupt the Commonwealth, I'll just, and we're going to file a written response. Let me just lay the groundwork for it, though.
Sure.
The court brought up the humane practice. We footnoted in a pleading. We never asserted humane practice. We're not asking for humane practice. Okay?
All right.
That is the bottom line here. And the Commonwealth's citation to sheriff in their latest briefing, they misstate what the law is. The law is if humane practice is a live issue, the court is required by law to give it humane practice. It's not a live issue. We've never raised it. So I want to set that groundwork.
All right, I appreciate that.
2, I understand what the court just said about you never intended to indicate you were going to exclude the presence of Tracy Miner. Our prejudice, contrary to what the Commonwealth argued in their brief, in their memo they filed last night, We made it very clear what the prejudice is. The prejudice is from the fact that Tracy Miner is there and all these statements are being made. Not the statements necessarily of Tracy Miner, but the statements of the client. And we made clear what we think the prejudice is. And that prejudice, once again, we'll lay it out in more detail, but that prejudice is the same type of prejudice that flows from the Commonwealth's reaction to Proctor and I won't go into anything about Proctor except for the fact that once Proctor's integrity was impeached, the Commonwealth moved away from him. Why? Because his impeached integrity reflected on this office, the Norfolk County District Attorney's Office. Our prejudice is that what happened at these interviews, that Tracy Miner was there, that the jury can take that to say, as we said, either he's lying to his attorney, therefore he's lying to us, and they can't believe our representations during the trial, or his attorney was complicit in the misrepresentations he was making to the police because she chimed in, but she was there, and so now we're making misrepresentation on his behalf. That's the type of prejudice we're trying to avoid, and finally, we're going to be arguing, why is it relevant, especially when you take the humane practice out of it? There is no relevance to Tracy Miner being there. So we'll brief it, but I wanted to lay the groundwork for that.
All right. So I appreciate that preview. And I appreciate the reminder with regard to the humane practices, both for myself and also to the Commonwealth as we move forward and try to resolve this issue for you.
And could I just make one more suggestion? Please. If the Commonwealth could take the highlighted sections that we provided to the Commonwealth and you.
Yes.
And just now go take those highlighted and maybe color code all of these statements they've listed. Wouldn't it make it easier for us all?
I think we can get down to I think if you get rid of the cumulative stuff, you're really probably down to not a lot.
Right.
So that might be a good idea. What do you think about that?
I think you're right, Your Honor. I think that the issue became with the transcripts. Once you started taking her out, it became confusing. So she would actually ask a question and he would answer it.
Right.
Or she would correct him on the restitution figure 3 times in a row. So then he's just shouting numbers out. It doesn't make sense. So a lot of it was just confusing with what was being proposed. So we're trying to go back and be more strategic about this.
All right. And so my goal is to make things clearer and easier for the jury
Yes.
than confuse them. And so to the extent that that you're having that situation where there's a question that she's asking that he's answering, and it's cumulative, the relative prejudice, I understand the argument, and I'm not ruling on it right now, Attorney Tipton, because once she's there for one answer, she's there, your argument is going to be the prejudice attaches. I understand the argument. But it's also incumbent upon me to provide evidence to the jury that they can, in a manner that they can consume it. And if it's doing so, once I balance the prejudice in a way that allows them to digest the evidence. But I'll think more about the prejudicial issue. And maybe you can get, there really is not a lot that she says that he doesn't repeat. So how about Friday on that color coding?
Yes, Your Honor.
All right. That's all the motions eliminate, right?
Yes, Your Honor.
All right. So, not much else that I have other than The jurors that were called in today were being used for a civil case. They're going to be told at the end of the day that they're being held over till tomorrow. And that's so that we will get a big yield tomorrow, and hopefully I'm hoping to take 70 of the jurors tomorrow, and the remainder will go hopefully to Crim 2 so that they can get their work done too. And then every day they're going to be held over. So we will have jurors right through till Friday, because as you know, typically we don't get
No
jurors on
Fridays.
Friday. And we'll seek to 16. Any questions that you have lingering that you need answered between now and tomorrow morning on anything?
No, but I would ask to come to sidebar on an unrelated matter to this case,
Okay.
when the time comes.
Anything the Commonwealth needs?
No, Your Honor, I think that we'll work together and try and figure out some of the other issues we've talked about today. I've been keeping a running list and just trying to make sure that we stay on schedule.
All right. I will see you at the side of the bench.
Yes, jury selection is going to start tomorrow. They are starting tomorrow on jury selection, and they are going to be also keeping jurors through Friday, which is unusual for Norfolk Superior. Usually they don't call in new jurors. But she says, I think, did she say there were 70 jurors? And she's going to hold them over until tomorrow. So they are starting. No, they don't. They're not putting them up in a hotel. No, because all the jurors are local to Norfolk County. So they will be starting jury selection in the morning. Yes, 70. Very interesting. It looks like Larry Tipton is very excited to cross-examine Michael Proctor. We're a little bit behind, so we can scooch a bit through this sidebar. He looks very excited. Can you imagine how explosive that's going to be? Focus again on Mrs. Walsh, Brian's mom. Who else is in the courtroom? Wait, let's see. Don't know. Don't recognize any of those people in the front row. Long sidebar. No, the jury will not be sequestered. No. They rarely do that, I think, in Massachusetts. Have they? When's the last time you can remember them, anyone who's local, sequestering a jury in Massachusetts? It gets very expensive. They typically, most courts don't do that anymore. They didn't even want to pay for Wi-Fi in that courthouse until right before Karen Read's first trial. And air conditioning. That was an issue too, remember?
See each other. We'll
Okay. Oh, wait. Freeze frame.
So the plan is we'll see each other. We'll end today's work. I appreciate the commitment to do some further work on issues, but I think we're really in pretty good shape
Yes, Your Honor.
as we move forward to the start of this. I will get you later this afternoon what I believe is the most updated witness list, which will be attached to that supplemental questionnaire. Take a look at it carefully, and I made some changes, some other minor changes that you'll see in there.
And I think we'll be able to give the court the binders of the internet stuff with spreadsheets of the isolated ones that we're looking at.
All right, that sounds good.
Thank you, Your Honor.
Have a good day, and we'll see you back here at 9 o'clock tomorrow morning.
You as well, Your Honor.
Thank you. Matters continue to November 18th at 9 a.m. Thanks, everyone.
9 a.m. tomorrow. They're not going to televise jury selection. Sometimes they televise the beginning of it, where they address the jury. We'll have to see if anybody's going to be streaming that tomorrow. Brian Walshe being cuffed again and taking his hammer haircut and going on his
I
way.
like to keep it simple method.
Saying bye to mom. Somebody said she looks a little bit like Ana, and she kind of does. The tie was horrible. I agree. I'm sorry. Mrs. Walsh, could you pick out a better tie for your son for tomorrow?
Hey,
They're predict-
Di.
They're predicting the
I
trial
know
will last
Soraya
4
mentioned
weeks.
to you taking down your stuff for the court reporter. Court reporter's not going to be here till Thursday, so we'll need you at least tomorrow and Wednesday. All right? Thank you.
Last I heard, they were thinking the trial was going to be 4 weeks.
This is the same binder I gave you this morning. So this is what I proposed to give to the clerk to, same binder.
His mom is a lot younger than I thought. I don't know why I thought she was like an elderly, frail woman from everything that I was reading in the pretrial stuff.
That was previously sent to.
I'd like to hear the hot mics until it runs out.
These are the charts that Greg talked about. There's a copy of the iPhone mini thing. This is my proposal to go to the judge as well. Exactly.
Somebody said Laura McGlock. Lynn was on vacation, but it's a long vacation. She's been on vacation for a long time, so I don't know if she's coming back to the space. or not.
Greg,
Yes, okay, sorry, before I still.
And that's it. That's where it ended. Brian does look like his mom. Walsh is in his 40s. There's extensive show notes below the video. For those of you who are not familiar with this case, there's also an extensive summary. And they will be back in the morning at 9 a.m. to start picking. Opening statements scheduled to begin on December 1st. So that will be our next gavel to gavel trial. And we're here for it. We're excited for it. A couple of interesting things that happened today. And that is, apparently the bone evidence is out. The bone evidence is something that a lot of people have been hanging their hats on. She said it was moot. And so I need to just double check on that. So don't report that yet. Either they came up with evidence that it was bone or they've decided that it's moot. And because a lot of these things have not been scanned into the system yet, I don't have access to them yet. Okay. There will be a pool camera. I believe there was a media order that there was a pool camera. And Sue said something earlier about we get a Zoom for the trial with everyone muted, meaning all the participants on the Zoom will be muted. But my understanding is there also going to be a pool camera because I think there was a media order early on that somebody asked to come in, and they've had one for every hearing. So I don't know why that would change for the trial. But I think that they said Zoom was also going to be used, and I'll have to double check on that as well. And I will recap in a minute for everyone who is late. Don't worry. Congratulations to you, Buff's mom, for going to your first Ragged Rocks concert in May with your daughter, who's a Buff, completing her freshman year. Thanks on top for your super sticker. And Lynn said, this is a hard case, in my opinion. I think he's guilty, but he deserves a fair trial. I'm not sure he's going to get one. We'll see. Did the Commonwealth send Troop B to Serbia? Thanks, Tracy, for your super chat. Kate asked this earlier, and I started. It says, "Why? Can you explain why all of this is talked about before a trial?" Yes. All of these motions in limine are decided before trial because, number one, each side needs to be able to prepare for trial. So they need to know what evidence is coming in and what evidence is being excluded, because you don't want to prep your case based on evidence that's eventually going to be excluded. And then you're not going to be able to talk about it, right? So it's very important that much of this stuff is decided ahead of time so that you have the opportunity to prepare. These attorneys are very lucky because they're going to have 2 weeks to prep for trial. That's very unusual. Many times you pick a jury and then you start opening statements the day after you finish picking the jury, or sometimes you finish picking in the morning and you have to start your trial that afternoon. So they're getting a full 2 weeks from today to start. That's hilarious. Wait, hold on a second. Stop. Hold on. If you guys didn't just see that message and the person that was just sent to Block Island, it's hilarious. Yeah, you're right. I'm jealous of Nan Gallagher and Jennifer Coffendoffer. You're right. You caught me. Oops. How sad for me that I have that extreme jealousy. Well done to you. Well done to you. Congratulations on your 3 minutes of fame. So then they have enough time to prepare and they know what they're preparing for. Here is the summary of all of the things that they talked about today. Greg Connor is going to be the lead attorney on this case for the Commonwealth. He's a very, very well-seasoned attorney. He is probably the top attorney for the Commonwealth. I don't know what happened to Adam Lally, but he's nowhere near this case. Originally, this case had been assigned to Judge Cannone, and then it was specially assigned to Judge Diane Freniere, which is who you, if you are tuning in for the first time to this case, we've seen her many times. She was sitting in a different courthouse, but now she is actually in the building at Norfolk Superior. Greg Connor, he is second seated and third seated by Ann Yaz, YAS, and Tracy Cusick for the Commonwealth. I'm not sure whether Laura McLaughlin is coming back to this case. For the defense, we have public defenders Larry Tipton, who is #1 public defender in Massachusetts, in my opinion, and I'm leaning towards now Kelly Porges, KELLI with the gorgeous red hair, is second chairing him, and she seems to be amazing, and I'm very excited to see her try a case. Also a public defender. Mr. Walsh was allowed to have his handcuffs removed today so that he could take notes, and the judge does intend to allow him to have no handcuffs for the trial. For the motions in limine, we heard that they are going to allow Zoom. They're going to mute everyone, all of the participants in the Zoom, so that nobody can say things such as like, free Billy Tibbetts. Free my boy Billy Tibbetts. That won't be happening during this trial because I think everyone learned a lesson from that, because Jim in the KAREN Read trial didn't know how to apparently mute the Zoom. We heard that during some pretrial motions. They are going to address the issue of supporters outside the courthouse if and when that is necessary. I brought up the fact that they may not have trial on December 5th when Aidan Carney's motion is supposed to be heard in the afternoon at 2 p.m. And so they may have a half a day that day. I'm not sure, but I'm sure they'll bring it up in due time, because the supporters outside the courthouse will be there for Aidan Carney, not BRIAN Walshe, clearly, but they want to, minimize any influence that those supporters may have in front of the jurors, so the jurors don't have to deal with that. And that's probably a good decision, although they haven't brought that up yet. That's my own personal opinion. Those are my thoughts on it. So the most important thing for them to discuss today was the jury questionnaire, which we didn't really hear too much about. And I don't have a copy of that jury questionnaire, but if I do, free Billy Tibbetts. There you go, Carol. Free Billy Tibbetts. Free my boy, Billy Tibbetts. And then people get mad when I say that, because they're like, Billy Tibbetts is a really bad guy. And I'm like, I really don't know much about Billy Tibbetts, except I think he was a hockey player. It's pretty much all I know. Smash the like button while I'm thinking of it. Thank you for reminding me. That'd be nice. She said something about whisper technology for strikes, which I am imagining. Well, you know what? Google is my friend. So let's look it up. What is whisper technology? Because I can't be deemed to know everything, right? Whisper technology in Massachusetts refers to several distinct applications and research areas, primarily the OpenAI Whisper AI model for speech recognition. And I don't know. It's an automatic speech recognition system that transcribes the spoken language into text. That's what they use anyway, right? The court reporters in Massachusetts speak into what looks like an athletic cup, in my opinion. And that is what they use. They don't use the old-fashioned stenography machines that we use still here in New York. And so there is a whisper-based tool, I guess, that they use. If anybody has any other information on that, let me know. Right. Mama MSN says, I can't believe they have any new technology in Massachusetts. We also learned that the judge is going to tell the jurors that in order to serve on this jury, they are not going to be able to use any social media or look at any social media or watch any news or any media during the course of the trial. That's a big ask. And it may rule out a lot of younger jurors, in my opinion. I mean, they didn't even go that far for the Karen Read trial. They're not supposed to post about the case or look at news about the case. But in this case, she wants them to stay away from social media altogether, in addition to not watching the news or any media at all during the course of the trial for 4 weeks and the 2 weeks until the trial starts. That's a big ask, in my opinion. Thank you. Thank you, Sheree. Filing 225 on 11/2 is about media. And she did say that a still camera was allowed, but I thought she also said that there was a video camera allowed. We'll see. Whatever it is, we'll deal with it. Whatever it is, we'll deal with it. She also did say, I think, that she was not going to give the attorneys copies of the juror questionnaires, which is very odd to me because here in New York, they make copies of all the questionnaires and they give them to all the attorneys so that you can mark them while that juror is being questioned. I need a little more clarification on that because I think that Nebraska Jeff says that's completely unreasonable to ask them to stay away from social media and news. I also think the attorneys should get copies of the questionnaires, but again, nobody's asking me. They're going to do individual voir dire only, which is also takes a long time. They call each juror up individually. We saw that in a recent trial that we watched. Panel voir dire is where they put, in my experience, they put 12 in the box and they're allowed to talk to them all at the same time and ask general questions to all of them. It's faster, it's quicker, but that's not the way that this judge is going to do that. And also, we learned some things by the comments that the judge made during today's proceedings that, she's uncertain why civil discovery is broader than criminal discovery. And she had questions about that that the attorneys had to answer. And so that gives me a little bit of pause in that maybe she is more familiar with civil litigation and not criminal trials. But somebody pointed out that she was the judge on the Ricci trial, right? The Christina Ricci trial. And so that also was a murder trial. Nancy said it's not her first murder trial. She was the judge for Christine Ricci, who took her husband's life. So there's that. But it makes sense now when I go look back on her ruling about the consent search and whether it went outside the consent search, which in my opinion, if Brian Walshe is convicted, that will be overturned on appeal. It's just my thoughts. And you're here for my thoughts. So I'm certainly willing to share them with you. The defense is to provide to the Commonwealth by Wednesday the reciprocal discovery on the experts. He's willing to give them a summary of each expert's testimony by Wednesday. That apparently Larry Tipton has not done yet. And so he will give that to them by Wednesday. There was also some chatter about Steve Verano testifying for the defense. And you might remember that name from the Karen Read trial. Wasn't he part of the taint team in the Karen Read trial and also in the Aiden Carney trial? The name is familiar to me. The jurors are going to be allowed to have a laptop in the jury room. That's very common so that they can view the evidence at their leisure, as long as the defendant is allowed to review the laptop before it goes into the jury room to make sure there's nothing else nefarious on the laptop that the jury is going to bring in the room with them, because that laptop is going to be provided by the Commonwealth. There was a little bit of kerfuffle when Larry Tipton was told that he was going to have to show the court and the Commonwealth any chalks or exhibits or posters, let's say, that he was going to use in his opening. And he didn't want to give away his theory of the case. And I agreed with him. And she said, well, we're going to have to get a ruling on that. And he's like, I've been doing this for over 20 years. I know exactly what I'm doing. But as long as he shows it to the Commonwealth and the judge the morning of the trial, that's going to be good enough. So she wants to make sure that Larry Tipton is not showing the jury anything that's not going to be allowed into evidence. He, on the other hand, did not want to give away his strategy to allow the Commonwealth time to refute that in their opening. And so that seems to have been agreed upon. There were some other motions that were decided with regard to reputation testimony, that whether or not they could introduce evidence that Ana was a loving mother and a dedicated employee. And I think those are going to be decided on during the trial. She really didn't rule on that in its entirety because, it's going to be a game time decision on what each witness is probably going to testify to with regard to Mutlu, who's the friend that was invited over on New Year's Eve. He was there. And perhaps some coworkers of Ana's. In-court identification was allowed. It usually is. There was something that we're going to circle back to regarding law enforcement bad acts having to do with Proctor and such. And I have that starred here. And I don't know if they ever circled back to that, did they? We're going to have to look for some of these written rulings later because they did rush through this pretty quickly. Then we talked about the 4 recorded interviews that were recorded by law enforcement and whether or not some redactions are going to be made with regard to Tracy Miner, who was Walshe's attorney at the time. There still hasn't been any clarity on that because they need to go through it line by line and talk about which statements they want redacted. And Greg Connor is going to have to color code all of that stuff for the judge, and then they're going to discuss it further. They wanted to show a short video and photos of the way that Ana normally appeared. And the reason they wanted to show that video is because she's sitting on a rug that was later found in a dumpster where they have video of BRIAN WALSHE approaching that same dumpster. The video is out, but the still shots can come in because the judge found at sidebar that that video was prejudicial. And it probably showed her being a very kind and loving mother to her children. And so that could be inflammatory or more prejudicial than probative. And there are some still photos with her in the black jacket that was found in the dumpster, and the watch and the necklace that were found in the dumpster. She's going to allow that, but she just wants like one photo of each. She doesn't want them to be able to show, cumulative photos of her wearing that jewelry because she said one is enough. With regard to the federal charges, it looks like the federal charges are not coming in. Tell me if I misheard that, because that's what it sounded like to me. The federal charges of BRIAN WALSHE involving him, and he eventually pled guilty to that, selling fake Andy Warhol paintings on eBay to a collector of Andy Warhol paintings. Doesn't look like that's coming in. And it also doesn't look like the GPS that he was wearing, the ankle monitor, is coming in either, because the GPS was a radio frequency bracelet and it did not show his whereabouts. It showed what time he left his house and how long he was out of his house. And so I have in my notes here that the judge found little evidentiary value to that. And I don't think that's going to be allowed in. That is a win for the defense, because the jury heard that he was on an ankle monitor and he had all these other federal charges. They could then make the jump that he also killed his wife. There was a lot of discussion about the victim's out-of-court statements. Ana Walshe's out-of-court statements to her best friend from D.C. Her name is Alyssa Kirby. And the things that she told her, yeah, it would be prejudicial. Good, thank you. Sometimes my notes are chicken scratch and I can't read them. So thanks for chiming in there, Allie. Thank you. We learned some interesting stuff that we did not know before about Ana's whereabouts on Christmas. So what had happened was we already knew that Ana went to Ireland for Thanksgiving with her boyfriend, William Fasto, who's her boyfriend, real estate broker from Washington, D.C. And we now learned that Ana claimed that she missed her flight on Christmas Eve. So she drove back on Christmas Day from D.C. to Cohasset, not arriving home until Christmas Day at 8 p.m. We also learned that she left the next day on the 26th to drive back to DC. And then she flew back to Cohasset, or to Boston, on the 30th of December. She went missing in the early morning hours of New Year's Day, 2023. And so then there was some discussion about how there was alcohol involved when she was talking to her friend, Alyssa Kirby. And they wound up in a karaoke bar at 1:30 in the morning. And my notes said that she was going to give a limiting instruction on that. But also that's great fodder for cross-examination too, right? If Alyssa's going to be able to talk about the things that Ana told her, that's great fodder for cross-examination. What, were you drinking? How much were you drinking? How much was she drinking? And that was a conversation that was had on the 29th with Alyssa Kirby in Washington, D.C. There was also some conversation or some talk around William Fastow testifying about Ana telling him that she didn't know what BRIAN WALSHE would do if he found out about the affair. And so it seems unclear what the judge is going to do about those different statements between the different witnesses, but she did say she would consider a limiting instruction and tell the jury, that it's not to be considered for the truth of the matter asserted, but it could go to the state of mind. But then again, there's no evidence that BRIAN WALSHE knew any of this, right? DC to Cohasset is 400 miles. Look at Mitchell doing the Lord's work out there. And what was the weather like? Was there a blizzard? Was it snowing? How long would it take? Also, some talk about some text messages between Ana Walshe and William Fastow and whether they're going to be allowed in. And we're not sure yet on that either. We're going to have to wait for the written decisions on this because a lot of it was kind of unclear. Then we learned about, they spoke about the internet history from the devices with Walsh's residence. And there are 3 huge binders of browser history that they want to introduce to the jury, but they also agreed or admitted that all of these, because of the way they're extracted, are duplicate searches. And then they were specifically talking about the corn searches regarding cheating wife and cheating wife threesome and gets impregnated, and whether or not those searches were going to be allowed in. The MacBook searches alone were 1,000 pages long. Then there was some discussion about whether or not the evidence was going to be allowed in that that BRIAN WALSHE's mother, Diana, hired a private investigator on December 28th to surveil Ana, or December 27th, I think, and that she paid him, and that she told the investigator, I don't want my son to know about this. But then there was some talk because she went to a psychic. The psychic had entered the chat too. I don't know if it was Miss Cleo. I don't know if it was the Long Island medium. We don't really know what psychic it was. And then the judge said, but didn't BRIAN WALSHE give his mother the name of Axios, the private investigator? So they went to sidebar and they talked about that a little bit. And we don't really know because the judge said, you don't even have Diana Walsh on the witness list. And then the defense said, well, we do. And then they found out Diana Walsh was sitting in the courtroom, so they made her leave. So we got to look at Brian's mom, Diana Walsh. The Capizoli stuff is out, which I find very interesting. So for those of you who don't know, BRIAN WALSHE and Ana Walshe rented that house that they were living at on Chief Justice Cushing Highway in Cohasset. And Diana Walsh was the one who signed the lease for them. I don't know if they had bad credit. I don't know what the situation was. But Diana Walsh signed the lease with this guy Capizoli, who was the owner of the home. And after they left, and after Ana Walsh went missing, and after the police searched and tore that house apart, Capizoli sued Diana Walsh for the damages to the home. And a judge said, none of that stuff is coming in. Or actually, I think it was the Commonwealth who said, we're not going to bring that stuff in, which is also very interesting. I'm sure that guy has photographs of the condition of the home, and I really want to see those photographs. They also said the bone evidence is moot. And so I need to go back and check on that. But the last time we read the motion in limine from the defense, they said that bone was never tested and or it was never confirmed to be animal bone or human bone, and she said it was moot. There will be no evidence of commendations to any law enforcement. And let's see. Oh, some talk about Larry Tipton is not going to ask for the humane practices instruction. And so I saw a lot of questions in the chat about that. What is the humane practices instruction? Google is my friend and your friend too. Massachusetts humane practice requires that when a defendant's confession or admission is offered in evidence, the judge must initially decide at a preliminary hearing, which was today, in the absence of the jury, whether the Commonwealth has proved beyond a reasonable doubt that the statement was voluntary. And so there was some talk about that. And then Larry Tipton said he's not going to ask for that instruction. And they're going to have to go line by line through his statements and decide what it is that's going to come in that Tracy Miner said, or whether it's going to be excluded. And that has not yet been decided. The jurors are going to be held over until tomorrow. And they want 16 jurors, 12 on the jury, and 4 alternates. And they're coming back in the morning to pick a jury. Thoughts, questions, comments, concerns? Carla said earlier, is Proctor testifying? He's on the defense list. Commonwealth is never going to call him, but the defense will. And you could see from Larry Tipton's demeanor today that he really, really, really can't wait. He can't wait to get Proctor on the stand. It's going to be the highlight of the trial. Holly says, thanks for bringing us all these cases to light and not only covering them, but sharing your knowledge so we can better understand the law. It's my pleasure. Thanks, Holly, for being here. Holly says, was the wife's DNA found in some or one of the areas he dumped her supposed remains? Well, it's gonna remain to be seen. Let's see what evidence comes in. We know that they found a Tyvek suit. We know that they found a watch and a necklace, and they found a rug, but it remains to be seen what evidence is going to come in and whether they found her DNA and who's going to testify to that. But the bone is out. And for me, the bone was a big thing, right? That was a big thing for me and a big thing for a lot of you too. But I think that some of her DNA was found on that Tyvek suit, right? And his DNA also was found on the Tyvek suit. And they may have found some DNA in the basement, but I'm not sure about the dumpsters. Lola says, hi, Mel. I'm going to go into the Forum tomorrow night to see Pat Benatar and Brian Adams. I hope you come back to LA soon for more concerts. I love the Forum. That's one of my favorite venues. But my favorite venue in LA is the Hollywood Bowl. So have a great time, Lola, the good dog. And thanks for your super chat. Amber says, can you help explain humane practices for what? There you go. I just did. Thank you, Amber. I remember. And thanks for being here for 24 months. I remember you asked that earlier. And that's why I pulled it up. On top says, that's the biggest lie of 2025. I don't remember what you were talking about then when you put that in, but thanks for your super chat. And Brigitte says, is reminding everyone to hit the like button and subscribe. Thank you. Thank you so much. It's free. And Mavka says, shouldn't the judge rule on the law, not the facts? She should. Yes, she should absolutely rule on the law. 100%. James says, thanks, Melanie. Looking forward to this trial with you. It looks like it might get spicy. Love with all my heart. Love with all my heart too, James. Thank you very much for your 10. Robin Rose says, I'm worried about this judge. In every case I've ever covered, felony court judges have the most criminal experience and sit at a higher level, full circuit and elected, not appointed. I don't know what jurisdiction you're from, Robin, but I think that that is very interesting too, because you see here, and we saw this in the Karen Read civil. I think it was the Karen Read civil hearing that we watched recently, that the judge had a murder jury out, and then he was hearing Karen Read's civil case the same day. So that was very odd to me. Here in New York, our judges are elected. They're not appointed like they are in Massachusetts. And our judges are elected. And typically the judges that run for criminal court are criminal defense attorneys or prosecutors. And the judges that run for civil court have civil litigation experience, and the judges that run for family court have family court experience. And so it's bizarre to me too, but it's the way Massachusetts is, and they rotate these judges in and out every couple of months, which is also strange to me because again, here in New York, when you're assigned a judge, the judge stays your judge for the entirety of your case. Oh, well, this is interesting. Hold on. I got an interesting thing from Boston, from Boston.com that I'm going to read to you in a second regarding defamation claims by the Alberts and the McCabes. That's interesting. Thanks, Katie, for sending that to me. Let me just finish this before we move on to that. Salted Ruby says, why give this cold-hearted con man any public attention? He is truly enjoying his fame. This judge needs to stop these preschool choices. Get these lawyers in line. I don't know what you mean by that, but the lawyers seem to be very well behaved to me. And I don't know, I'm just going to toss this out there, but just because he is a con man, and I'll agree with you that he is a con man, there were some shenanigans that went on with his father's will as well, but does that mean that he's actually a murderer? I don't know. You decide. It sounds like you've already decided. So there's that. Starter Villain says, if I'm ever accused of a crime, I hope I can afford a good attorney. Well, you know what? These are public defenders. So Larry Tipton and Kelly Porges are public defenders, and they are excellent, in my opinion. And so, listen, there are public defenders out there who are doing the Lord's work, who are very, very, very excellent attorneys. Chrissy says, how can you think she's alive and left her children? Well, have you been watching the whole stream? Because she left them on Thanksgiving. She left them on Christmas. And I don't know if she's alive or not, but I will say that there is a theory that's being floated out there that she may have been a Serbian spy or involved with some very dangerous people, Serbian mob-wise. And so, you know, that spies do that. I don't know if she's still alive. I don't know if I believe those theories, but I'm just telling you that it's possible. Have you watched The Americans? Hold on. Innocent until proven guilty. All right. Let's move over here and talk about what Katie just sent me. This will be a cold read because I'm just looking at this for the first time. But according to Boston.com, 10:32 a.m. this morning, we're right on this. This was only about an hour ago. Boston.com is reporting that in the Karen Read case, the Alberts, the McCabes, and the Higgins are eyeing defamation claims against Karen Read and Turtleboy. Let's put it in reader mode so we don't have to look at the pop-ups every 30 seconds. This was published just this morning, hot off the press. The witnesses from Read's high-profile murder case are denouncing her cover-up claims as a vile work of fiction. Boop. There's a picture of Big Bad Brian Albert staring down Karen Read during the course of trial number 1. Must have been during closing arguments because remember, he came back during closing arguments and some of the jurors said that they were intimidated. Oh yeah, look at that. The caption says, Brian Albert listens during closing statement arguments in the first Karen Read trial at Norfolk Superior Court on Tuesday, June 25th, 2024 in Dedham. Still hounded by conspiracy theories months after Karen Read's acquittal, several witnesses from the high-profile murder case are denouncing Read's cover-up claims as a vile work of fiction. The outlandish frame job allegations were part of Read's, quote, scheme to defame and wrongly malign prosecution witnesses and evade responsibility for the death of her boyfriend, John O'Keefe. Lawyers for Brian and Nicole Albert, Jennifer and Matthew McCabe, and Brian Higgins argue in a new brief recently served on Read's legal team. Where's the brief? I need the brief. All 5 witnesses attended an ill-fated after-party at the Alberts home in Canton, where O'Keefe's badly wounded body was found in the snow on January 29th of 2022. Prosecutors allege Read drunkenly backed her SUV into O'Keefe while dropping him off at the gathering, but she claimed investigators and after-party guests conspired to frame her. In June, a jury found Reed not guilty of her most serious charges, convicting her only of a drunk driving misdemeanor. However, Reed's legal saga is far from over. She still faces a wrongful death lawsuit from O'Keefe's relatives, who maintain Reed was to blame for killing the Boston police officer. During a September hearing in the civil case, Reed's lawyers announced her plans to bring legal action against several witnesses and Massachusetts state police investigators, further complicating the proceedings. Reed is seeking to combine her conspiracy and civil rights claims with the wrongful death suit for efficiency's sake, but a judge has yet to rule on the request. Well, it hasn't. I haven't seen any papers on that yet either. The Alberts, the McCabes, and Higgins are asking that Reed's motion be denied and that her claims filed in a separate case. The Commonwealth witnesses vigorously dispute defendant Reed's allegations and will defend against these false claims, their lawyer explained. This must be a response to Karen's motion to add them to her civil suit, because remember, during the civil hearing that we watched in September, I believe, Karen Reed's attorney said, we intend to bring in 10 more defendants, including the McCabes and the Alberts and other people who directed the investigation away from themselves, in addition to Proctor and others. So this is the response to it, but I don't think any of it's hit the docket yet. So what I assume that this is, because Massachusetts has this weird rule where they can't docket anything until all the responses are in. So the motion plus all the responses will be docketed at the same time. And so we won't get to see it until then. Unless anybody has a copy of it, email it to me. But this seems to be an opposition to Karen Reed's motion to add all of them to the civil case. Yeah, Higgy is alive, apparently. They said that their defense will include motions to dismiss a potential request to move the claims to federal court. Oh, please. That would be amazing if it goes to federal court, because federal court is no joke and moves very quickly. And counterclaims against both Reed and Turtleboy blogger Aidan Carney for defamation and other torts that they have committed individually and in concert. Well, they can't counterclaim against Turtleboy because he's not a party to the action. They'd have to bring him in as a party first. A staunch supporter of Reed's innocence, Carney racked up several criminal charges after he was accused of intimidating witnesses in the case, including the Alberts and McCabes. Authorities later alleged Reed leaked non-public information to Carney, though she was never charged with witness intimidation. Meanwhile, Carney maintains his actions were protected free speech. Lawyers of the Alberts, McCabes, and Higgins said they had, quote, planned to seek justice in a separate action over allegations that Reed and Carney defamed and substantially injured them through myriad false statements. Combining those defamation claims with Reed's conspiracy claims and the O'Keefe's wrongful death suit is procedurally improper at this stage and will make for a much more sprawling case, the lawyers argue. Reached for comment on the potential defamation claims, Reed defense attorney Damon Seligson said via email, truth is an absolute defense to a claim of defamation, and we will defend Karen Reed vigorously against such baseless claims. Notably absent from the opposition brief is Brian and Nicole Albert's nephew, Colin Albert, who was also present at 34 Fairview Road the night O'Keefe died. While Reed previously sought to implicate Colin Albert in her third-party culprit theory, she has not named him in her civil conspiracy claims. The wrongful death lawsuit is due back in court on Friday. And this picture is, I believe, of the reporter, Abby Patkin. And so we will hear all about this on Friday, and we'll be covering that live at 2 p.m. on Friday. And so expect an explosive day of court on Friday in the Karen Reed civil case. Let me just hold on a second while I see if this hyperlink will tell me anything. No. Does not. Yeah, she did not say that she was going to bring her third party Colin in as a defendant in this case. And so that would explain it. I don't know how that reporter got a copy of the papers, but let me see if they're out there. Hold on a second. Civil discovery rules are very, very, very broad. Very broad. And so It falls under the category of you better want what you wish for, because Karen Read apparently has no fear in bringing the McCabes and the Alberts and Brian Higgins in, as well as Proctor and others. And they will all have to give depositions and swear to tell the truth under oath. And civil depositions can go on for days. They can go on for days. I'm not aware of any time limit on civil depositions in Massachusetts. If you are, you can let me know. This absolutely will be going on for years and years and years and years. Many, 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 many years. Boop. Thank you, Anne, for your Venmos. Thanks, Melanie. This is a very interesting case, she said, about BRIAN WALSHE. Thank you very much. Lori, thank you. Says just a note of thanks. I don't really chat much, but watch always. Appreciate your hard work and dedication. Thank you very much, Lori, for your Venmo. Brenda, also, thank you very much for your Venmo. Venmo's doing a weird thing where, like, I'm thanking people on Venmo and the comments aren't showing up. So if you've left me a Venmo and I haven't thanked you on air, trust me that I sent you a thank you note, and it's weird. Is anybody else having this problem also? Here's another problem on my iPhone, and tell me if you're having this problem on your iPhone. When somebody sends you a link to a YouTube video and you click on the link to the YouTube video, it just takes me to wherever I was last on YouTube. It doesn't take me to the video. So if you're telling me that you're blocked and you're sending me the link to your channel, the only way that I can unblock you is on my phone, and YouTube is having a glitch. And it's been like that for a couple of days where it does not take me to your page. It takes me to my homepage. And I had to Google it and fall into the rabbit hole. There's a whole Reddit thread about it. So it's a problem. It's the new update for YouTube. I know everyone's having this problem. And do you also have an iPhone? It's a pain in the neck. So annoying. And it's happening on Venmo. And I don't know if it's just iPhones. I don't know. But hopefully they'll fix it soon. Because it's annoying. I want to go right to the link. I don't want to go to where I was last on YouTube. It's Mercury in retrograde, probably. Thank you on top for your super sticker. I don't know if I already thanked you, but thank you again. Nancy seems to know a lot about the Walsh case, and she said earlier that Ana's friends Pamela and Natasha have been assisting the state with keeping the kids together while in state custody. Interesting that Ana's mother has not been to the USA once. She's in Serbia, I believe. Megan said, did they investigate the Christmas Eve canceled flight? I don't know. I guess we'll hear some evidence about that. Thanks, Megan. I don't know the answer to that. Toasty Bun says, RIP to Amber Check, who was murdered at her workplace last week. I'm not familiar with that case, but prayer hands up for Amber and her family. Thank you, Toasty Bun 71 for your super chat. David said, too many people assume that successful, beautiful Eastern European women must be spies. Well, I'm not saying that she must be a spy. I'm saying that based on what happened in the Washington, D.C. apartment complex where she lived, in which those men were attempting to infiltrate the Secret Service. And listen, they're doing time in federal prison. It's like a real thing. And so I'm not making that generalization. I don't think people are making that generalization. I think it's based on the facts that she was managing that apartment building where that happened. And many, many residents of that apartment complex said that her actions during that time were kind of sus, right? Those of you who fell into the rabbit hole, just Google it. Ana Walshe, Washington, D.C. apartment complex, Secret Service infiltrators or something like that. It is fascinating, right? It's a rabbit hole that you can fall into. Right. Magnolia Gypsy says, I think it's more that a demonstration that she engaged in some risky behaviors. Right. And perhaps was hanging around with the wrong crowd, you know? So else. And so there's that. Tiffany said, so do we think that this is going to turn into like 15 seasons? LOL. Maddie McCabe thought it was just going to be an episode. Well, that reminds me. Let me just look in the docket here for a second. Oh, please. Talk amongst yourselves for a second. Mitchell loves a spy story. Okay, so those papers have not yet been docketed in the civil docket, but a new judge has been assigned to the Karen Read civil case, and his name is Mark Gildea, Gildea. And so I believe that Judge O'Shea, who we saw at the last conference, is retiring. And so there has been a special assignment of Judge Mark Gildea, Gildea, in Plymouth Superior Court to the Karen Read case. And so perhaps we will see that new judge on Friday. We should, because this was signed on November 14th by the Chief Justice, Michael Ricciuti. And so that is also what is happening here. Maybe she was spy adjacent, said Mavka. Maybe she was spy adjacent. Agreed. Could be. I don't know. Nebraska Jeff says it's more common in DC and big government areas than most people realize. Very, very interesting. David says they weren't trying to infiltrate the Secret Service. They were trying to gain influence with them. I'm going to have to go back and read all of those articles, David, but they were pretending. They were with the FBI or the Secret Service or something is what I recall. Thank you, David, for your super chat. Defense Diaries. Hi, Bob. Is this courtroom in the basement of the courthouse? No, they were in the big courtroom. What are we talking about? BRIAN WALSHE, that was the big courtroom in which many of Karen Read's hearings were held. That is the main courtroom. And that is also, I think, where Sacco and Vanzetti were tried all the way back in like the 1920s. And it is, there were a lot of Karen Read pre-trial hearings that took place there as well. All right. I heard rumblings that there's going to be, well, the Cosgrove's motion, Cosgrove's papers to the mega motion are due today. If those happen to drop and they're made public or we get them, we will cover that later today. And I do not think that any of these papers regarding the Alberts and the McCabes will surface, but if they do, we will cover that today. So make sure that you are subscribed. Make sure you have all your notifications enabled. Make sure that your notifications are enabled on your phone and all of that good stuff so that if I come back this afternoon, which is quite likely based on all of the craziness that's supposed to happen today, you won't miss it. Okay? Thoughts, questions, comments, concerns before we wrap it up. The McCabe's, Alberts, and Higgins are apparently coming out swinging. They're coming out swinging. I can't wait to see the papers. But if they've been brought in by Karen Read, they had to oppose that. And so that is not a standalone thing. That was in opposition to Karen Read's motion to bring them in. All right. Thank you very much for hanging out with me today for 3 hours. Wow, this was longer than I thought it was going to be. But there could be more this afternoon, so you don't want to miss that. So, thank you, moderators, for keeping it classy today. I know there's been a lot of craziness going on, a lot of trolling and whatever. And what are you going to do? What are you going to do? If you don't have haters, then I guess you're not making an impact. Stay cool, stay kind, stay classy, you guys. I know that you can do it. I know you can. I'm going to see you real soon, probably in a couple of hours. All right. Peace out, you guys. I love you all. Bye. Peace.